Good morning. I want to welcome everyone to the July 2026 oral arguments before the Kansas Court of Appeals. My name is Sarah Warner. I am the Chief Judge of our court, and I'm joined today by a distinguished panel. To my right, your left, is Judge Kim Schroeder. Judge Schroeder was appointed to the Kansas Court of Appeals in 2013 after spending about 14 years on the district court bench in Stevens County in Hugoton. And then to my left, your right, we are very pleased today to be joined by Judge Jason Geyer. Judge Geyer is a district court judge who's sitting by appointment with our court. Judge Geyer hails from Shawnee County in Topeka. The court will hear 3 cases this morning. In preparation for today, we have thoroughly reviewed the record, the briefs that have been submitted by the parties, and a memorandum that has been prepared by a research attorney who works for the court. So we are very aware of the facts of each case, and so we encourage the parties and the attorneys to just jump right into their oral arguments because each of these cases has 15 minutes of arguments per side. With that, we'll turn to the first case before us from Wyandotte County, case number 128829, Efrain Gonzalez Jr., appellant, versus State of Kansas appellee. Would the parties please state their appearances?
Good morning. I'm Jonathan Lawrence on behalf of Mr. Gonzalez.
Good morning. The State of Kansas appears by Assistant District Attorney David Greenwald as appellee.
Welcome. And Mr. Lawrence, would you like to reserve any time for rebuttal?
I'd like to split 10 and 5 if I might.
5 minutes of rebuttal are granted, and with that, you may proceed.
May it please the court. In Kansas appellate history, there are 2 other cases where there have been 4 findings of deficient performance. One of them is from 2014, Wilson versus State. It's at 51 Canap 2nd 1. The other one is somewhat famous case, In re Ontiveros. It's 295 Kansas 10 from 2012. It's the case that extended Strickland analysis to KSVPA. That's not what's relevant. What's relevant is both of these cases had 4 findings of deficient performance, and the Court of Appeals in Wilson and the Supreme Court in Ontiveros applied cumulative error analysis. I would like to start out at the back of the case, at the back of Judge Cahill's order, and note that Judge Cahill misapplied or misstated, however you want to say it, the cumulative error test. What he said was, since there's no prejudice found for each of the 4 deficient performances, there cannot be cumulative prejudice, and that's not the test. The test is, let me digress a second. And the reason that's wrong is if there's one finding of prejudice, that moots everything else. So you got a finding of prejudice on a deficient performance. Now you have met the entire Strickland test, and you don't need to reach the other 3. So I would submit to the court, although I believe each of the 4 had their own prejudice, 3 more than the 4th, at the very end of the day, it's really hard to say that there wasn't cumulative prejudice here. I think the worst error is when you have a lawyer pick an unavailable defense, and this was a guy who was going to go to the wall with it. You can see it in the evidentiary hearing transcript. Paul Franco took the stand and right out of his mouth says, it was never my intent to rely on the defense of mental disease and defect. That was just for sentencing mitigation. The case was hopeless, and I was just going to start with that. And then okay, let's do it this way. Hand him Exhibit 1. What's this? Oh, it's the notice of intent to rely on the defense of mental disease and defect. So I knew I was dealing with somebody who did not want to be honest. Next question, which is of equal importance to picking the wrong defense, is complete ignorance that there is an available correct defense. And I say, does Kansas recognize involuntary intoxication? No. If it did, would you have used it? Absolutely, but it doesn't. Kansas doesn't recognize that. And then I bring him the 3 jury instructions. You have a lawyer who was so out of touch and had never cracked a law book, as echoed by Mr. Haggard and his local counsel, admitted the same thing, didn't know that he picked a wrong defense. The facts lined up with the right defense, and he didn't know that the right defense existed.
Well, counsel, how could he have presented an intoxication defense when the defendant chose to not testify?
Well, and that is one,
I mean,
No,
I think that's correct. The defendant
right, no,
chose not to testify.
right. What's interesting is that was one of the 12 instances of ineffectiveness that I raised in the 1507. Judge Cahill did not specifically address it in terms of, he didn't make a finding whether it was deficient or not to misadvise Gonzalez whether he had to testify. He just said that there was no prejudice. But your question leads right into the second instance of ineffectiveness. They bring in Mr. Espinosa, the shooter, the actual murderer in this case. They bring him in on a subpoena, and Caleb Boone comes in and says, well, he's going to assert his fifth. I believe Espinosa did appeal his sentence. There was a direct appeal. It doesn't matter. It was already in the rearview mirror. And he had already missed the time deadline for 1507. And Boone says to Judge Fairchild, because Judge Cahill didn't try the case, Judge Fairchild did, and says to Judge Fairchild, he might file a 1507 in the future, and Fairchild sustained that. That was part of the direct appeal. But the point being this, Franco and Hagerton didn't even know that the case law says that when the 14 days for your notice of appeal runs, or the time for review after an appellate decision runs, your Fifth Amendment right ends. You can short circuit all that. What they should have done is very simply, oh, you want to take the fifth? No problem. Judge, the 2 officers who took his confession, Espinosa's confession, they're testifying in this case. They're the 2 lead detectives. When they take the stand, I'm going to give them Espinosa's statement, which you have by stipulation. It's Exhibit 4. It was at page 5 of the evidentiary hearing transcript. It was stipulated in evidence by the state, no objection. But the bottom line is at trial, you just hit those 2 cops with, let's go over Espinosa's confession. It's a statement against penal interest, and he's not available now. He took the fifth, so he's an unavailable witness. It's just classic textbook hearsay. They didn't even know that. So that would have populated the defense. In my brief at page 18, I list out all of the statements that Espinosa gave about Gonzalez's drug ingestion and his state of mind.
Back up though. If the officers would have testified under the hearsay exception, wouldn't they have testified about the conspiracy to commit a robbery?
They did testify about that, but it's a jury it's still a jury question whether Espinosa's drug ingestion was sufficient to a level where it robs him of his mens rea. That's a jury question. So Judge Cahill, who didn't try the case, said, no, he was in his right mind. There's enough evidence.
It strikes me that that's a choice that the defense attorney made, right? And maybe your argument is that it wasn't an informed choice, but it's a choice. Do you want to bring these officers out and ask them questions that could be very damning or not?
Well, what I'm saying is this. You need a witness to put in a hearsay statement. They're already testifying. They're already giving the damning evidence. The point being, their defense.
Who's giving the damning evidence?
The two officers. They're already testifying for the state against Gonzalez. My point is.
But they didn't have any real evidence against Gonzalez.
No, but they were the 2 main witnesses against him. And what I'm saying is this. When Espinosa becomes an unavailable witness by invoking, incorrectly, but invoking the fifth, and Judge Fairchild grants him that status, he's now an unavailable witness. So the statement that you have, Exhibit 4, that's now fair game. That's admissible. You need a witness to do it. The most logical witness are the 2 cops, right? Or you could have played the video for the jury, but you're still going to need a witness to say this is the video. You're still going to need the cop. But the point being, your defense as the defense attorney was, let's go back to the beginning. He's got mental disease or defect. Why? Drug ingestion. Okay. So where's the drug ingestion evidence come from? There are 2 witnesses. One would be Gonzalez. who testified at the 1507 hearing, he was never told, because they didn't even know that intoxication was a defense. So he was never told, we need you to populate that defense with testimony, right? Even if you are going to overlook the fact that he was misadvised on whether or not he should testify, you still have Espinosa's statement. Espinosa says he basically was unconscious. His quote was, he was zoned out. He was awakened by the gunshot. Like, Gonzalez is passing in and out of consciousness, driving around like a fool. I grant that. But he's so high on Xanax, marijuana, and the other stuff he was taking, that he's not fully conscious. And Espinosa is the one who gives that statement, says he was zoned out. And Espinosa is giving that as part of his confession, so it's fully admissible. So that is also an error. It's a double error. It's number one, not knowing that Espinosa can't take the fifth. He can't, right? Because the time for his appellate rights and his post-conviction rights had already expired. Defense counsel didn't know it. Unfortunately, Judge Fairchild didn't know it, but it's defense counsel's error. So,
Counsel, I want to make sure that we have time to address your cumulative error argument.
Yes.
And so would you talk me through the argument or the finding that you think that Judge Cahill should have made?
he should have said there was no defense. You picked an unavailable defense. You didn't know about the viable defense with the same facts that you were relying on for your unavailable defense. You didn't correctly call the witness who would have provided the testimony for that defense. And then I think this is just as grave an error. You let the state put in an unconstitutional jury instruction. The Supreme Court earlier this year in a case called Wright at 321 Can this year once again underscored, you cannot be convicted of aiding and abetting on a reasonable foreseeability jury instruction. These guys didn't even know, they didn't even read the jury instructions. They didn't even know to object. Those errors compounded together left this young man with absolutely no defense whatsoever. None. They just had two lawyers who just showed up and.
I'm having a hard time with the lawyer should have called the co-defendant when the co-defendant would have laid all of the groundwork for a plan to rob, aggravated robbery and their conspiracy to commit robbery. And without him being a witness, there was no testimony of that.
The officers testified to that.
Only upon counsel's question.
I believe that the officers testified about the text messages that they construed to be the evidence of a plan.
Yeah, but that's pretty vague.
I agree, but
so until the defense counsel asked a specific question of the officer, what evidence do you have of Gonzalez? He went in, he opened the door for testimony that was not admissible without that question.
Your Honor, all due respect, it sounds like, if I'm hearing correctly, you're imputing a strategy to Franco and Haggerty that they didn't have. The idea being it was not a good strategy for them to call Espinosa. They wanted to call Espinosa. They tried, they subpoenaed him. They didn't know how to overcome his invocation of the fifth. It was fully their intent to put Espinosa on. That, you see what I'm saying? Like,
right.
they're not disagreeing with me that they needed Espinosa. They just didn't know how to do it. And what I'm saying is, once Espinosa takes the fifth and it's acknowledged by the judge, there's nothing you can do about it. But what you can do is say, great, now he's an unavailable witness. The stuff I wanted to get from him about how high and out of his mind that Gonzalez was. Remember, this is a guy who dug a bullet out of his foot with his fingers at the hospital just an hour later. Espinosa.
Want to make sure we're going into your rebuttal time. I just want to make sure that that's
All I would conclude with is Espinosa would have been forced to acknowledge what he said in that videotape statement that is Exhibit 4, the transcript of it that's in the record.
Thank you. You still have 5 minutes for. Welcome, counsel.
Good morning, Your Honors. So this is a case where Judge Cahill found that trial counsel, Mr. Franco, was deficient in certain areas, but everything then turned on whether or not it ultimately would have changed the outcome. And I think that's what is very important for the court to look at and assess in this case.
And counsel, just to be clear, the state isn't contesting any of those findings by Judge Cahill that we indeed have several errors here.
Well, I sure would like to, but I'm not going to.
The state did not, I shall.
We did not, Your Honor.
Okay.
Ultimately, this wouldn't have changed anything. Voluntary intoxication is a potential defense, but just because it is a hypothetical defense doesn't mean it's one that the defendant would have been entitled to. We set this out in our briefing, but mere evidence of consumption of drugs or alcohol isn't enough to reach the threshold to even get the instruction. So even if Espinoza had testified, Espinoza, in addition to saying a number of things that actually would have inculpated the defendant and said that he had a lot of culpability, it was his idea to rob, saying, well, I watched him do some Xanax, wouldn't have been enough to get to the level where Mr. Gonzalez could say that he doesn't know anything, that he couldn't have formed a culpable mental state. Frankly, Espinoza's statement gives the state the culpable mental state. It gives direct evidence of Gonzalez's culpable mental state, as opposed to the case the state put on, which was circumstantial. The text messages from Gonzalez to his girlfriend talking about setting up a robbery, show a level of lucidity. And had Gonzalez,
isn't that a speculation though? I'm hanging with whatever, and we're going to go get paper.
Well, so
that's the only thing that the text said, right?
We said, I'm my friend's grip, which is generally speaking what our detectives know to be the trigger man, the gunman. And then he later says,
grip means gunman?
Yeah, generally speaking, yes.
Okay.
The other part of that then is, he says, we just got dumped at, and I'm paraphrasing, but they dumped at Beto, who is Espinoza. So we dumped back at them. And that, again, generally speaking, means they shot at us, we shot at them. It shows some level of understanding if he knows what's happening, because he's more or less narrating this as it's happening.
That's somebody else that shot at him.
They're talking about what I'm guessing the victim in the case, Louis Scherzer.
Like you just said, I'm guessing. Do we have that in the record?
That there were shots exchanged back and forth. When the police found Mr. Gonzalez's car, it had bullet holes in it. There was a bullet hole in the back windshield. There was a lot of discussion back and forth during the trial about whether or not Mr. Scherzer carried a gun with him.
And wasn't there video that one of the detectives testified to that showed the victim firing his weapon back?
Yes.
Okay.
Yes.
And so you're setting forth the fact that Gonzalez was sending those text messages, Facebook Messenger messages, on my partner's grip. We're going to go get paper. Mr. Scherzer dies, is shot. And then afterwards, I believe it was to his girlfriend saying they got dumped on. So essentially, the defendant is cognizant before and after the crime, which would tend to lead to the fact that he was cognizant of what he was doing in the voluntary intoxication defense.
That's my assertion.
Okay.
Your Honor. Had the defendant testified in his own defense, which I think is not always necessary, but in this case probably would have been necessary based on what the other evidence available to him was, that opens the door for his proffer statement to come in, which would have also very seriously hurt his ability to put on his case, his voluntary intoxication, because he gave.
I'd like to talk about that proffer statement because so there's a proffer, it's not going to come in, and then the defense attorney just kind of stumbles into inviting all of these statements in. How is that not horribly prejudicial?
Yes, Your Honor. Well, I think it was the finding that Judge Cahill made, but that there was a pretty limited amount of testimony about what those statements were. The proffer itself didn't come into evidence. Detective Vaughn, I believe, kind of briefly touched on it, but neither party discussed that in closing argument. The state didn't talk about that in closing argument. It was not the basis for any of the state's case functionally. So you have a pretty limited amount of testimony from one officer during a 3 or 4 day jury trial, and then really no mention of it after.
But that officer's testimony says he admitted it.
Yes, Your Honor.
So isn't that pretty damning statement in the middle of the trial for the jury to consider, when that would not have been brought out but for the attorney's inept questioning?
Well, Your Honor, everything is a little speculative without having the jury to to tell us what their line of thinking was during all of this. But when you've got
Is the cold record.
right, my argument is that when the jury doesn't have the full proffer before them, so when Detective Vaughn says his admissions, they don't know that he made full admissions. They don't know what he said. They don't have any of that. Mr. Gonzalez made statements, as we just talked about, via Facebook Messenger or text messages, where he's talking about, they dumped at us, we dumped at them, so on and so forth.
But I mean, that as we've talked about, those statements need interpretation. So
Yes.
then you have to rely on someone else telling you what was meant by those statements. But here, the detective's testimony, that evidence would be his admission. That admission or that evidence would be the fact that they discussed pointing out the victim, identifying, pinpointing a victim, targeting a victim for the robbery, and they attempted to do that when they murdered the victim. I mean, that's laying out an admission of the elements of the crime.
Yes, sir.
I don't know how we can ignore that.
Well, I don't know that I'm asking you to ignore it, but I think ultimately at the end of the day, it doesn't
But how
fundamentally alter the outcome of the
could that not
trial.
be prejudicial? Because it would have never been brought to the jury's attention, but for the attorney's question.
Well, ultimately, Mr. Gonzalez does make statements that did come into evidence properly. Again, his text messages talking about being the grip, trying to get paper, all of those things came in anyway. So that little excerpt of Detective Vaughn's testimony is not so voluminous or directly, speaking to the proffer, even though that is what it was. But he doesn't go in to say, well, we took a proffer from him. He said X, Y, and Z in a statement to us that was recorded or any of those things. That it functionally just goes back to all the circumstantial evidence that the state presented with the text messages, the Facebook messages, video evidence.
Mr. Greenwald, I want to jump in, and I was surprised I didn't see this in either brief. I do not have the transcript in front of me, but I took notes. It appears on redirect with Detective Vaughn. There was a break for the day. He came back the next day and began testifying. And before he got into the proffer that defense counsel got into, before that, he goes, a question is asked about what evidence do you have that Mr. Gonzalez took part in this crime? I'm paraphrasing a little bit, but at one point he says he discussed the robbery. He talked about the robbery with his partner. So a lot of the evidence that came in with that proffer, in my opinion, it looked like that came in beforehand via unobjected to testimony that came in on redirect. And so in some respects, that was already in evidence. Would you agree or disagree?
I would agree. So at the end of
But the question, counsel, is whether eliciting essentially a statement of all of the elements of the crime from a witness, the defense counsel's statement or attempt to elicit that information, whether we can say that beyond a reasonable doubt that didn't affect the outcome. Can we say that?
It's tough to say. We can never say that something would put a finger on the scale one way or another beyond a reasonable doubt.
But that's the showing that the state has to make once we have an error.
Right.
So can we say that?
I think we can. The state presented a very strong case, and Judge Cahill set out the strength of the state's case when he reached his conclusions. And
Didn't the Supreme Court disagree about the strength of the state's case in the direct appeal?
they ultimately affirmed the state's the conviction on, and one of the issues on appeal was sufficiency of the evidence. And
it was also the issue of the aiding and abetting instruction and the use of the "I'm with my grip and we're going to go get paper." That's highly, basically, I'm paraphrasing, it's highly speculative.
right. Well,
but they ultimately upheld it because there was no timely objection to the aiding and abetting instruction.
well, so to, I guess, pivot to that issue, ultimately the state charged the defendant with first-degree premeditated murder. That was not a strong case, but the felony murder was based on the strength of the text messages between them, talking about functionally setting up a robbery. The reasonable foreseeability instruction was error to give. The state's not going to argue that at all. But as noted by the Supreme Court, once he was acquitted of premeditated murder, there was no prejudice or harm because he's convicted of felony murder. That he's convicted of a homicide that happened during a forcible felony. And so that makes the reasonable foreseeability instruction moot at that point. And so the strength of the felony murder case, the state's case was extremely strong. It wasn't necessarily strong for a premeditation case, but the strength of the evidence for felony murder was very strong. That's ultimately what he was convicted of.
All right. As I understand the facts, and I could be wrong, but the state's case had Mr. Gonzalez's car in the area of the shooting.
Yes.
They found his car with bullet holes in it. They found the gun at his mother's house. But none of those, without the statement of the officer that was asked by the attorney, show any agreement to commit a robbery.
That goes back to the messages, the Facebook messages and the text messages.
Which are, in the words of the Supreme Court, questionable.
Respectfully, I would disagree with the Supreme Court's assessment that that is questionable. As somebody who does prosecute in an urban, jurisdiction, that's pretty common parlance. We are familiar with what those mean. I think the detectives can testify to that. And I think the jury found that credible because saying that you're a grip is something that in Kansas City, Kansas, we're very familiar with that phrasing. I'm trying to get paper. We're familiar with that phrasing. And with all circumstantial evidence, when you look at the context surrounding something, you can start to fit it all together and you know what that means. And so those statements in context with what all happened do paint a pretty clear picture of a robbery attempt that ultimately resulted in a homicide.
So if I tell my wife I'm going to go get some paper at the bank, does that mean I'm going to commit a robbery?
Well, in that context, it means most likely that you're just going to the bank to withdraw money. But if there were other pieces of evidence, if a robbery ultimately happens and there were other pieces of evidence that would support that statement, then yes.
Counsel, I'll tell you what I'm having a little bit of difficulty with, and you probably have found it from my questions, is that a direct appeal and a question as to whether or not there is sufficient evidence is a very deferential standard to the existing conviction, because we have to look at everything in the light most favorable to the state. So we have to, so the Supreme Court would have to take whatever, the statements, even if the justices didn't have the context that you were explaining, and so found these to be speculative, they nevertheless were evidence that supported the outcome. But on a habeas corpus case, we have to think about whether we are convinced beyond a reasonable doubt that this did not affect the outcome, which is not a deferential standard to the state. If anything, it is the antithesis of a deferential standard to the state. So how do I reconcile those two positions?
Yes, Your Honor. So I'd like to think of it, if we were to take the defendant at his claims that he should have presented his voluntary intoxication defense. Had he presented it, whether that was him testifying or putting the co-defendant on the stand, the state would have been able to present sufficient evidence to counter his voluntary intoxication defense. There's not a guarantee he would have even reached the threshold legally to get the defense. But even if he had presented the defense, it would have opened the door for the state to present such strong evidence against him that it would have made it even more likely that he would have been convicted. The co-defendant says it was his plan to commit a robbery. So while the co-defendant might have said, I saw him do a lot of Xanax and drink alcohol, he in the next breath would have said, it was also his plan to try and set up a robbery, which goes to the ultimate crime he was convicted of, which is felony murder. The same thing goes to that instructional error, which is, while yes, it was error to give the reasonable foreseeability instruction, once the defendant is acquitted of premeditated murder, that becomes moot because he's convicted of felony murder. And that instruction doesn't apply to the felony murder part of it, or the mens rea of it, because it's a murder committed during a forcible felony. So ultimately, while there were errors committed, if the defendant had it his way and these errors hadn't been committed, in many ways, based on what's already in the record, the state's case would have been even stronger for a felony murder case, and we would have ultimately gotten to the exact same spot we're in right now.
Thank you.
Thank you, Your Honors.
Mr. Lawrence, you have 5 minutes.
I could just pick up where he left off. And I wasn't able to just exactly put my finger on it, but that reasonable foreseeability instruction was for the aiding and abetting charge. That was absolutely in play, and it was, he's guilty of aiding and abetting if the shooting was reasonably foreseeable. Right, so that instruction is in play. Addressing sufficiency.
Does that come into play when you're talking about a felony murder conviction, though, when you just have someone, not just, but when someone dies during the commission of a robbery?
Well,
Does the aiding and abetting instruction come in, or was that instruction just about premeditated murder?
That instruction's been declared unconstitutional, so I'm a little confused. It had to be beyond a reasonable doubt. But in the context of Gonzalez's jury instructions, that reasonable foreseeability instruction went not to first degree murder, but it went to the aiding and abetting and the other charges. Standing here, I'm not, I mean, to me, the instruction's unconstitutional, so there wouldn't be any application to felony murder as we're standing here today. Before it was declared unconstitutional, I'm not sure. If I could turn to the sufficiency, the Supreme Court listed Gonzalez's statement to the police as the linchpin of its sufficiency analysis. So there's the problem there. If you want to, going back for a second to the reasonable foreseeability jury instruction at page 34 of my brief, I set forth all the arguments that the state made in its closing about reasonable foreseeability. This was a harmful instruction. They leveraged it. They used it. They told the jury, hey, if it's foreseeable, he's guilty. So that's not a harmless error, that instruction. What I hear going on when we talk about if Espinosa testified, the state would have done this. This is what lawyers do, right? This is what we do pregame, prior to trial. It's just like football. You're watching film, you're guessing and pinpointing the strengths and weaknesses of your opponent's game plan, and then you are prognosticating how you would address it. But the fact of the matter remains, a jury is to decide the voluntary intoxication defense and then decide whether the other evidence overcomes it. Because what we have here is an inference, right? All that's raised by the text messages ahead of time, and let's just be honest, it was a typo. It says, "Tana get this paper." It should have said, "Gonna get this paper." That's a drug phrase. I'm gonna go get paper. I'm gonna go do a drug deal. Paper's money. That's not a robbery phrase, but that shows consciousness at that moment. And then his text message afterwards about the shooting shows consciousness at that moment, but it's only an inference that he was also conscious and awake and aware during the incident itself. And what we know from Espinosa's statement, he's zoned out. The shooting is what wakes him back up and he drives off.
Our Supreme Court has said behavior before and after a crime is a great indication.
Sure. Right. It's an inference. It's circumstantial. But the direct evidence is Espinosa saying he's zoned out. He's not with us. What it comes down to is this. We're talking about whether under Supreme Court Rule 183 and under the statute 1507, there's a preponderance of evidence that Efrain Gonzalez was denied effective representation. They gave no defense. The defense that they intended was prohibited by Judge Fairchild, and they didn't have a response for it because they didn't crack a book to know that Kansas had 3 jury instructions on voluntary intoxication. They didn't know how to put Espinosa on the stand. If this is held to be constitutionally sufficient representation, and I don't mean this to be facetious, I don't want to be hyperbolic, but really 34 years, this is the worst ineffectiveness of it. This is all I do is post-conviction. If this is upheld as constitutionally sufficient representation under the Sixth Amendment, then we have to ask ourselves, do we even need Rule 1.1 on competence? They admitted we chose the wrong defense. We didn't know about the right defense. We didn't know that Espinosa didn't have a Fifth Amendment right. We didn't know about hearsay. We didn't research the foreseeability instruction. And then, of course, yeah, we were the ones that elicited, or Franco was the one that elicited Mr. Gonzalez's statement, months later to the police trying to get a deal. I ask that this be reversed for new trial with competent counsel. Thank you.
Thank you very much. We'll take the matter under advisement. Thank counsel for your arguments, both in writing and today, and we'll get an opinion out to you as soon as we're able. At this time, we'll take just a minute and then I'll call the second case. So I'll allow the attorneys to kind of we're going to do some changing of the guard, but we'll just remain in here. Thank you. Thank you. We'll wait just a minute. Please be seated. Our second case is also out of Wyandotte County. It's case number 128738. Joshua Sammons, an individually and a special administrator of the estate of Brandy Sammons, appellant, versus the University of Kansas Hospital Authority appellee. Would the parties please state their appearances?
Michael Blanton on behalf of the appellant Joshua Sammons, Your Honor.
Thank you.
May it please the court, Trevin Ray on behalf of the defendant appellee, University of Kansas Hospital Authority.
Thank you. And Mr. Blanton, would you like any time for rebuttal?
3 minutes.
3 minutes are granted. And with that, you may proceed.
Defendant would have this court believe that this case involves complicated issues of policy determinations regarding organ transplants. That's simply not the case. This is a basic medical negligence case in which a hospital failed to maintain its own internal records and it failed to communicate with its own patient. But before getting to that core issue, I'd like to briefly touch upon the disqualification issue in this case. There's no question that Judge Mahoney's sister served on defendant's board, and Judge Mahoney should have disqualified himself because of that fact. The Kansas Code of Judicial Conduct, Rule 2.11A2, says that a judge shall disqualify himself under those circumstances, and the case law has recognized that those circumstances require disqualification. And Judge Mahoney agreed at the hearing. He had known that his sister was on defendant's board, and he conceded that he had never given the parties or the attorneys any notice of that fact. And so the judge should have disqualified himself, but not just at that moment when it came up at the hearing, because the comments to Rule 2.11 state that it's a judge's obligation not to hear or decide matters when those circumstances are present, regardless of whether a motion to disqualify is filed. So when a judge has the conflict that we've identified under 2.11, a judge shouldn't just wait to see if anybody raises it and address it on a motion if somebody files a motion. A judge should recuse himself from the beginning of the case under that standard.
Counsel, while I appreciate the seriousness of what you're discussing, we also have a lot of case law that discusses the fact that just like the rules of professional conduct for attorneys are not dispositive in, say, a legal malpractice claim, neither are the judicial canons dispositive as to whether it's not structural error. We still have to show that there is some kind of a prejudice that it's affected the outcome. And what can we point to show that it affected the outcome?
I would disagree with the premise because I don't think there is a requirement of bias or prejudice under 2.11A2. Under 2.11A1.
I'm not talking about the canons. I'm talking about a recusal case law, which says that there has to be a showing of prejudice. It's not a structural error. So what is the showing of prejudice or bias that you can point to?
I don't think there is an express showing of bias. Again, the basis of our complaint isn't prejudice, although the rule speaks in terms of circumstances in which impartiality might reasonably be questioned. And I can tell you, our client certainly questioned the impartiality of Judge Mahoney after learning of the conflict that Judge Mahoney had. But aside from that, I still disagree with the premise. The Supreme Court has recognized on multiple occasions that there are separate bases to seek the disqualification of a judge. KCJC, the statute, which speaks to bias and prejudice, and due process.
And
which
was
involves...
the statute followed here? Was there a petition that was presented to Chief Judge Burns?
No, but we weren't pursuing disqualification under the statute, and the Supreme Court, it was in the...
But you're claiming reversible error now?
We are claiming reversible error and not that the judge should have disqualified himself. We're claiming that the opinion should have been vacated because the judge should never have been sitting to issue the order that it did pursuant to the KCJC. And the Supreme Court has recognized that they're alternate bases. The KCJC and the statute are two separate bases. The language of the cases literally says 3 different bases to seek disqualification. So if you're seeking disqualification under...
With the affidavit with the chief judge.
No, because again, that's part of the statute. That's part of 2311. We weren't proceeding under.
But if you wanted him to be disqualified, why not pursue all of those avenues?
Again, it is another method that was available to us. It wasn't the method we used, but we did use KCJC, and the Supreme Court has repeatedly said that is also an alternate basis for seeking disqualification. The language of the Supreme Court cases expressly recognizes that. So I don't think we were required to use one method over another. The case law doesn't speak in terms of that.
The statute provides the complaining party an option for somebody other than the judge that's being asked to recuse to decide whether he or she should.
And I'm not arguing about how the statute works, Your Honor. Again, we weren't proceeding under the statute. We were proceeding under the KCJC, which has been identified as an alternative basis for disqualification by the state Supreme Court. I'm happy to answer more questions. I hate to spend too much more time because I'd like to get to our core issues.
More on point, in my opinion.
Okay, I will move there right now. So again, defendants suggest that this case is about the national transplant system and policy decisions, but this is really just a medical negligence case. And to see that, I think it's important to look at where the negligence occurred. There's no question Brandy was on the transplant list. Nobody disputes that. And when somebody's on the transplant list at any given moment, their status is either active or inactive. And the way that happens is the hospital communicates that back. It's like there's a switch. You switch it on for active, you switch it off for inactive, and that comes from the hospital. And in this case, Brandy had a brief episode of bleeding where she was put on temporarily inactive status. But the defendant then failed to flip the switch back on, which should have happened fairly quickly. And there's no dispute that Brandy was erroneously maintained in a temporarily inactive status for a significant period of time. The district court literally held in its own judgment that it was erroneously maintained temporarily inactive status. So there's no question that the hospital made a mistake.
Would it ever have been proper for her to be in temporarily inactive status? Or was it just a miscommunication between the physician and the person who actually typed in that trigger?
So frankly, there's a dispute about whether she should have ever been inactive at all. But assuming that she was, it was for a day or two, and she should have been quickly moved back to active status. And again, the district court recognizes it was erroneous to leave her on inactive status. And defendant recognized that there was a period of nearly 2 months from September 8th to October 27th when she would have been eligible for receiving organs. And defendant's experts have explained that she likely would have gotten one, and that likely would have saved her life. But not only did the hospital fail to keep adequate records, the hospital also failed to communicate with its own patient. It was the hospital's practice that when a patient was put on inactive status, they would inform the patient of that, and they didn't inform Brandy.
Who has the power to put somebody on the donor list or take them off?
It's an entire process. To be frank, Your Honor, I don't know all the details of the ins and outs, but again, there's no question in this case about whether Brandy should have been on the donor list. She was on the donor list. This case isn't about whether she should have been on the list or not. It's simply about whether that inactive switch should have been flipped back on to active and rather than being left in the inactive status. And the hospital also, not only did it fail to inform Brandy she was on inactive status, but the hospital then on 2 occasions when Brandy contacted the hospital to ask about her status, the hospital erroneously told her that she was fine. She was active. She was still on the list. So we have 3 separate acts of negligence, and the court should have dealt with those from the perspective of the reasonable standard of care. Kansas courts have long recognized that that is the standard for a hospital, it's in the PIC instruction. A hospital's duty is to use a degree of reasonable care required by that patient's known physical condition. That's the long recognized standard in Kansas. Rather than focusing on that standard, instead, the court looked at the specific task and it defined the duty in terms of the specific task. And can I get a drink of water real quick, Your Honor? I apologize. I woke up a little raspy this morning and
These allergies, right? These allergies. Welcome to July in Kansas.
I apologize for that.
It's no problem.
So the judge should have addressed the duty from that perspective. And the duty arises from the hospital-patient relationship. It doesn't arise from the specific task that the hospital happens to be engaging in. And that distinction is important, and it was addressed recently by the Kansas Supreme Court in the Reardon decision. The court recognized in Reardon that we apply a reasonable standard of care. And the reason we do that is because it allows courts to avoid, quote, infinite factual circumstances that could exist. So in other words, rather than having 300 separate duties that a hospital might violate, depending on which specific action you happen to be talking about, we have an overriding duty of reasonable care. And it's a jury's job to decide whether specific actions violate that general duty.
As I read the district court's decision here, the district court essentially concluded that because there is not a common law duty to, or there isn't any right to be placed on the list to begin with, then that means that anything having to do with that list doesn't trigger a negligence claim. Is that an accurate description of the finding?
I think that is the essence of the court's finding. I think that's absolutely incorrect, both factually and under Kansas law.
So where is the action? I think that you've identified 3 things, but could you help me just parse it out a little bit more? Why is it that despite the fact that there is no common law right to be placed on the list, that we nevertheless can reach the negligence claim in the absence of any kind of triggering right?
Well, again, We're not, first of all, we're not talking about the right to be placed on the list. She was on the list. Nobody disputes that. There's no question. The error was the hospital's own record keeping error. It failed to update its record to note that she was inactive. Its record still said it was active. Do hospitals generally have a duty to appropriately keep their own records? Yes, they do under Kansas law, but it's not a specific duty about record. It's their general duty of care. Do hospitals have duty to communicate with their own patients? Yes, they do, but it's not a duty about a specific task. And when we talk about, defendants raise this idea that, well, because transplants are heavily regulated at the federal law, this is just different. Medications are heavily regulated at the federal law. And yet that doesn't change Kansas law of negligence. We frequently have cases with hospitals involving medication errors. Defendant similarly makes the argument that, well, the federal law doesn't create a private cause of action. But again, medication's highly regulated, and those medication regulations don't create a private cause of action for somebody to complain about a medication error. But Kansas has long recognized that medication errors are an appropriate basis for a negligence claim. I see my primary time is out. Unless the court has another question, I'll wait for rebuttal. Thank you.
You have 3 minutes that are reserved for rebuttal.
Morning, may it please the court. We have a mild disagreement on the order of presentation here, and if it's okay with the court, I'll address the right of action first and then the other issues after that, just because I think that predominates. One of the things that that's sort of lost in this is that we would not be here talking about anything but for the National Transplant Waiting List. That is a creation of federal law. So in 1984, the federal government passes this act that leads to this final rule that is the creation of the list. And the background for that act was attempting to make good stewardship of organs that become available, get them to the right places where they can be used and avoid wasting, and then also to eliminate an emerging black market where you sell donor organs to the highest bidder. So this standardized the entire process. It created this list, and it created the concept of being a transplant program participating in the list, which you must be. So the University of Kansas Hospital has a transplant program for certain services. Each hospital declares what they can and can't do on that, but they all must participate in the list. So the list itself, it's undisputed here. There's no right of action in the statute that allows somebody to contest their status on the list or whatever, take some action seeking to gain status, keep status, override medical decisions, whatever that is. That is not a statutory cause of action granted. The question here is, can you simply do an end around on that by affixing a common law negligence label to exactly the same thing? And so here,
So I want to stop just a little bit. And are there any common law negligence claims that could arise out of a transplant
generally. So once you endeavor to undertake the medical care, I think that you convert over to the usual medical standards. If you're
And when does one convert over to the medical?
when we're doing a transplant surgery. So if I can back up a step, if it would help, I can talk a little bit about the transplant process. If you look at, so what are all the stages between potential candidate and transplant recipient? There are lots of people sent over for evaluation, and a committee of physicians has to decide, is this person a valid candidate to be on the list at all first? So that has a myriad of things that by regulation are set out they have to consider. They include things like behavioral issues that might affect compliance, because you have to maintain a rigid compliance with anti-rejection regimens and things like this. It might include whether or not the person has past issues that may be repeated that would cause you to lose the organ. Now, nobody gets it. These kinds
We can fast forward through this because Ms. Salmons was placed on the list.
She was, but what they're asking for here, they can't just say, I want a common law cause of action for these facts. They are saying Kansas will be the first state in the country to, notwithstanding the National Organ Transplant Act, recognize a new cause of action that allows somebody to litigate status on the list. That's the point of error, is that.
But it is not, it isn't, it's a fact question, isn't it? The KU agreed to put her on the list and by error took her off the list.
Well, she didn't come off the list. That's one of the things you're opening this up.
Well, I mean, she became from active to inactive.
Right, which temporarily inactive. This is a thing that's required by
But
regulation.
boy, that temporarily inactive period was unfortunate.
She missed 5. She was first on the list for 5 transplants, wasn't she?
No,
During that inactive period.
well, no, we would contest a lot of the facts, but we're
But this
using
is
a
at
summary
summary
judgment.
judgment.
That's what I'm saying. Yeah, we're assuming a lot of things on their behalf. But really, it's a question of law.
Can we also assume that it was erroneous to place her on temporarily inactive status for summary judgment purposes?
I would say that it's right to conclude that the evidence was the internal designation and the actual listing status did not match. She was made temporarily inactive on the national transplant waiting list. Whether that was an error or the other one is a point of debate, but you can assume there is disagreement between those two, and you wouldn't normally have that.
So once the hospital, following this process that you had described, which is seems like a very rigorous process to place a person on the transplant list. Once the hospital has decided that this person should be placed on the transplant list, do they have no duty of care toward the person to make sure that that the hospital doesn't screw up to remove that person temporarily from a potential transplant?
Well, so the question though is, do they have a common law right of action in tort to claim, like they say here?
Do they have a duty of care toward their patient?
Well, that's the point. At that point, are they a patient or a candidate? What I'm saying is once you undertake the medical procedure itself, it's a lot more clear that you have the medical duty of care that applies. But at this point, when you're talking about enforcing status, they have a duty of care. If they did, let's say, I mean, would that then give you a right of action that arises out of the subject matter of the National Organ Transplant Act? Because there's not a.
But is this out of the subject matter of the National Organ Transplant List, or is it just hospital as part of this person's treatment, place this person on the list, whether, following all the procedures? It's not like she had a cause of action to be placed on the list, but hospital has placed her on the list, and then through hospital's error has prevented her from actually receiving the benefit of being on that list.
What's the universe of claims? You're not supposed to answer a question to the question, but forgive me.
Why don't you answer my question?
Well, that's what I'm going to try to do. The question is, okay, so let's say that there's a medical decision that she should be temporarily inactive. Does she have a cause of action in tort to litigate? I think that was a result of negligence. I think that decision should have included another evaluation, or it was an unreasonable judgment. I'm saying now in tort, I had the right to be on the list, to stay on the list, and to stay in active status, such that then now you're litigating those things. Would you have a cause of action then to say, I don't think the surgeon should have rejected an organ as not having sufficient quality to be transplanted? Because that's the other thing.
That's not the question that we have. The question we have is whether, under the facts of summary judgment, right, taking everything in the light most favorable to the non-movement, whether, given the error by the hospital as to basically flipping the switch and putting you on in temporary inactive status, assuming that was erroneously done, then is there no recourse?
Well, when you talk about recourse,
is there no recourse in the law? Was there no duty of care that was owed to the patient?
Well, there's no enforceable action of negligence that arises out of a status on the list. That's because that would have to be granted by the authority that creates the list itself.
But who has the power to put a person on the list?
A transplant committee, and they have
the hospital.
Well, the hospital's transplant committee, but it's made up of physicians. This gets into an irrelevant issue.
Right, but I mean, but it's in essence, the hospital has the authority to put a person on the list, and the hospital has the authority to maintain that list.
On the orders of its physicians. That's why I say it's.
Well, I understand that.
I'm not trying to.
But we're not but I'm just trying to get to who accepts the duty to put a person on the list.
That's, I think what I'm saying is I don't think you ever have a duty to put somebody on the list. I don't think that is a medical judgment.
But once you put somebody on the list, who has the duty to properly maintain the eligibility on that list?
Well, so that's, I think, what gets to the point, right? Is when we talk about properly maintaining eligibility, then they're asking for the opening of a new cause of action that arises out of the list. It would not be limited to, does this match this? It would have you would just get to claim a duty of care, and that it includes whatever you list that to be. I don't, and you can say you have a duty to evaluate me correctly. And I don't think that, I think that was breached. You have a duty to reach the right conclusion. I think that was breached.
That's not their claim, is it?
Well,
The
it's,
claim is that the failure to maintain the list.
well, that's their claim. That's part of their claim. I agree with that. But that's not what the question of law will be. The question of law will be, is this state going to be the first in the country after 40 years to recognize a common law right of action that affixes a negligence label to the exact same conduct or the exact same subject matter that is in the Transplant Act of 1984? And keep in mind, of course, this was raised and the challenge was presented, okay, find a case where this has actually been allowed to go forward. And there has been none. They've cited 4 cases in the briefing. 3 of them are federal district court cases. 1 is an unpublished Michigan Court of Appeals case, and none of them is actually on point. And if we wanted to discuss that, I would get into that. The point here is that they have not been able to identify if it's existing common law that allows this. Where are the cases where this has been allowed?
It strikes me, though, that this is a factually unique situation, because in many cases, there could be an allegation, but it would be very difficult to talk about causation. Whereas here, there at least seem to be some facts, again, at the summary judgment stage, but there seem to be some facts that put causation into play. So I mean, the fact that there are no cases doesn't surprise me.
Well, I think you would have to think along the way that people who want to be on the list, at some point, there would have been something that arose out of this, something that alleged or court said, yes, you can claim status. Remember, this is what the core of the claim is. It's a claim to active status, a specific status, not just something. Is
it a claim to active status, or is it a claim? And maybe we're just going round and round on this, counsel, but is it a claim to a particular status, or is it a claim that the hospital erred, and by that error prevented me from accepting a transplant that otherwise would have been available because I was on the list?
So can I break that into 2 parts really quickly? The first is the claim of error. I mean, says this, it says the hospital owes no duty to maintain a person as having an active status on the national transplant list when such status is warranted. We may quibble with how that phrases the district court's order, but that is the core of it. They are claiming a right to active status enforceable in tort and hindsight. And they've now pointed to Reardon as suggesting, I don't think it's correct to interpret Reardon as an attempt to basically broaden Kansas tort law to the point where it becomes a big due process violation where you absolutely never know what your obligations are, such as you can comply with them when they're affirmative acts. The Reardon itself said we're not splitting the claims. I mean, that was the context for that case. So you can bring causation into a lot of things. That's often going to be a debated point. But where the rule of law exists is to say, even in those times, this is just not a box we're going to open. And here, that is absolutely what they're asking you to open, is this box that says people can now come in Kansas and litigate their status on the list and say it should have been active. This is what gets to the causation issue you raised just a minute ago, Your Honor. There are a myriad of steps between placement on the list and receiving a transplant. And that was much of what was glossed over in some of the briefing underlying and then on appeal. I mean, I know you don't want to, I don't want to take the rest of my time going through all of them, but there are a bunch of judgment calls. You can get an organ offer and not get a transplant. That happened to Brandy Salmons once when there was an offer, but the surgeon said that is a pancreas of insufficient quality to transplant. The organ offer becomes immaterial at that point. None of this is material unless you are claiming an entitlement to eventually undergo the transplant itself. That's the other end of this. And there are a myriad of things. You have to come to the hospital to get there in time. You have to be in a reasonable condition such that you can withstand the surgery, et cetera, et cetera. And those are all judgment calls.
Questions about proximate cause are so tricky, right? But the ultimate question as to whether we have a cause of action at all kind of presumes that those could be made, those showings could be made.
Well, it would open the right to litigate each of those decisions. So you could litigate each of those against the surgeon, say, I don't think it was of insufficient quality, and I think that was a negligent evaluation. You'd open all of those things up for examination, and you'd put tort litigation finger on the scale of deciding who does and does not have a chance to get transplant, because there is far more demand than there will ever be supply.
Could you, and I just being wary of our time, I am troubled by the relationship between the district judge and the board member. I find that very troubling. Are you troubled by that?
I would say that am I troubled by that just in the abstract? I would say no, because I didn't see any manifestation of bias. It was not something that was discussed, and I don't think
Well, I mean, it wasn't discussed because he didn't bring it up.
Right, right. And I say, when you say, are you troubled by it? I think, I'm not trying to.
As an officer of the court.
Sure. Well, so this gets into a different discussion about we're probably the worst people to be heard on this, which is why we said, look, this is a matter for Judge Mahoney doesn't have to rely on us to speak for him. Who would listen to us on this point anyway if we don't make the connection, kind of a thing. But ultimately, the overarching premise of that rule is when a reasonable person would question impartiality. That's the premise, right?
Well, let me jump in on that,
Sure.
because his order denying the motion for disqualification said, for the reasons stated on the record, the motion is denied. Well, I went back and read the record last night, and he didn't give a reason. And so would that in and of itself, the fact that, yeah, my sister is on the board, but I stand by my previous decision. And that's pretty much it. You can appeal me. I mean, that's pretty much it. Is that in and of itself, the fact that he didn't really address it at all, is that evidence of bias?
I don't think I don't think it's on its own evidence of bias. I think that the idea of bias would be as it manifested in the actual order that is being challenged. And remember that they're claiming it was void. I mean, that to me is the more essential question is this order totally void? Because the idea is he should have disqualified the first. I mean, that's one of those things where you can't weigh in on that if you're me, because I can't tell you what the judge knew. I can't tell you what he concluded about when a reasonable person would, I mean, for example, let's say he hypothetically concludes, yeah, but that rule doesn't mean uncompensated membership on a 19-member nonprofit governmental entity board or whatever. That, that's up to the judge to decide, not for us to declare it. And so is that manifestation of bias? I would say, I don't think on its own it would be, but then is that then representative of bias in the final order? I say absolutely not, because that's just a pure question of law. He in fact treated all the facts and as in the light most favorable to the plaintiff. There's no evidence he discounted some facts because he or made statements that suggested he wanted a certain outcome over the other. I mean, all of the cases in the Kansas case law have, as Judge Warner identified, spoken of, okay, what's the ultimate effect on the outcome? Because this affects the litigant, right? If this order is void, sorry, doing that, then we start over, right? That's the idea. So there's not even an allegation that if there, let's say, was some sort of internal bias, that it produced something that alters the proceedings, because it's a pure question of law. So I've gone way over my time, sorry.
But isn't it the opportunity to avoid the appearance of an impropriety?
You mean the disqualification
Right.
part? So
I mean, the judge has a self-internal clock that should say, hey, maybe I should step out of this. There's other judges that can do it. If not, somebody else in the county can't do it, then the Supreme Court can assign somebody from out of district.
that absolutely is an option for them. That's why I say, I mean, I'm struggling here just because I'm.
Well, I know,
him on an ethical basis.
but I'm just saying, I'm not trying to put the ethical side of it. I'm just saying the appearance.
Well, would a reasonable person question impartiality in this scenario? That's, I think, ultimately what that rule requires him to decide. Now, it does have a sub, I'm not disputing this as a sub that says we would presume that if these things, but it goes really far, and it says third degree and their spouses, partners, they're on a board. It doesn't specify what kind of board. You have to have an economic interest. I mean, what are the situations that allow you to conclude a reasonable person would say this thing makes me question whether he's impartial? And it does leave it up to the judge to subjectively determine. Would it avoid it if you did that? Sure, I guess, but it also opened it up to weaponization, I guess, at some point, if you're going to, after the fact, claim, well, we should just invalidate everything that happened. That's, to me, that's the difference between Like there is this separate question. I don't purport to speak for Judge Mahoney. I think he should have the right to answer that question himself. But the effect is ultimately the question here is, does this void everything that happened? I think that the law says no, even if you conclude, well, it would have been a better idea to avoid it by not, by recusing or disqualifying.
Thank you for your answer.
Thank you, Your Honor.
Thank you. Thank you very much. Counsel, you've reserved 3 minutes for rebuttal.
Thank you, Your Honor. Defense counsel said repeatedly that we're seeking to create a new common law cause of action, and that's simply not true. There's already a common law cause of action. It's called negligence and has been recognized by Kansas courts for a long time. And not only that, we have an instruction, a PIC instruction based on Supreme Court cases, which tells us exactly what the hospital's duty of care is in a negligence action against a hospital. There's nothing new here. Even defense counsel concedes at some point the hospital has to be responsible for its own actions. Defense counsel wants to draw that line when the moment the surgery starts. Respectfully, I think the line is way before that. I see no reason why this case should be different than any other, where a hospital is responsible for its own actions that relate to the care of a patient. And that can be record keeping, and that can be communication with the patient. And the district court acknowledged in its own order, we have errors in both of those. There's errors in record keeping, and there were errors in communication. So I don't think we can just pick a line and say, well, it's once the surgery starts. The hospital's failure in this case is so clear cut. And again, there was a lot of discussion about the list. Defense counsel spent a long time talking about the list and the policy considerations. Brandy's already on the list. Nobody's questioning that Brandy's on the list. And not only that, this isn't even a case where we're really arguing about the hospital's decision-making process in terms of being inactive, because even the court recognized she was erroneously maintained in a temporarily inactive status. And the important word there is temporary. That was the whole idea. She should have been temporary, if at all. She would have been temporarily put on inactive status and then quickly switched back on to active status. And that was the hospital's error here. And then not only that, the hospital compounds that error by never telling her she's been put on inactive status. And in fact, when she calls to check at least twice, telling her the opposite. No, you're active. Everything's fine. You know, you are on the list. You're available to get organs. So
Counsel, before you conclude, I'll tell you something that I have been struggling with, and that is there is no common law right to a particular status on the list, right? And there is no private right of action to have a particular status on the list. The case law is pretty clear on that. So what distinguishes this case where there was an error or a series of errors from a case when someone is arguing the hospital decided to place me on temporary inactive status, but I should never have been placed on temporary inactive status, which seems much closer to the I want to be on the list, but I don't have a common law right of action to being on the list. So what distinguishes this case from just a disagreement as to what your status should
I
be?
think it's always going to be fact specific. I mean, if the reason that, and again, those aren't our facts. The dispute here is
But
not
we have to
about the
think about,
decision.
we have to think, when we're writing an opinion, we have to think about this case.
You know,
We have to think about the way that our words are going to be interpreted later. And so what distinguishes those two scenarios?
so because I think it's a error that occurs solely within the hospital. That's why I talked about it's important to look at where the negligence occurs. This was a hospital record-keeping error here, the hospital's failure to keep its own records, and that's not something new. There are many cases that involve hospitals failing to keep accurate records in one respect or another, and this case should be treated no different than any other medical negligence case in that respect. The same with communication. I mean, again, we don't define duty in terms of what specific task we're talking about. We define duty in terms of the overall duty of reasonable care. And I don't think transplant cases are treated differently in that respect. Again, same with medication, as I noted, highly federally regulated area of the law. There's no independent federally created cause of action for a medication error. But there are many cases where Kansas courts have recognized that when a hospital or doctor makes a mistake about medication, that's actionable. Doesn't make any difference that there's a federal system for determining which drugs should be legal and which ones shouldn't and how we triage drugs. None of that makes any.
Counsel. I think that answers my question. And I did interrupt you right as you were closing. So if you'd like to take a few seconds and close.
Yeah, and just in closing, I appreciate that, Your Honor. Again, this order should have never been issued because Judge Mahoney should have been disqualified from the beginning of the case and the order shouldn't have been issued. But even if you do look at the order, I think the judge's order is entirely inconsistent with Kansas law regarding what the duty of care is for a hospital. I think that's been true for a long time, but I think it's especially true given the Reardon decision. And I would note the Supreme Court has doubled down on that analysis 2 times since the Reardon decision. Granados, and I believe it was 22. And then again, just last year in the case of Stroud v. Ozark National, 320 Can 180. So this wasn't a case where the Supreme Court said something inexact and it's not clear what they really meant. The Supreme Court has emphasized it meant exactly what it said. And in the Supreme Court's own words, duty rules are not meant to be fact specific. That's where the trial court erred here, Your Honor.
Thank you very much.
Thank you.
I want to thank both counsel for your arguments today and for your written briefs. A very interesting case. We'll take the matter under advisement and we'll issue an opinion just as soon as we're able.
Thank you, Your Honor.
Thank you. At this point, we'll call the third case on this morning's docket and allow everyone a little bit of time to turn around and get into their places. That third case, also from Wyandotte County, case number 128644. Amy Whitney, on behalf of herself and others similarly situated appellant versus the University of Kansas Hospital Authority, appellee. Would the parties please state their appearances?
Jake Miller and Barry Grissom on behalf of the appellant Amy Whitney and others situated.
Good morning, Lauren Tucker McCubbin on behalf of the defendant appellees, University of Kansas Healthcare System and its employee-sponsored benefit plan.
Thank you. And Mr. Miller, would you like to reserve any time for rebuttal?
5 minutes, please.
5 minutes are granted. You may proceed.
May it please the court, Jake Miller on behalf of Amy Whitney, appellant in this case. This is a simple breach of contract case. The Supreme Court has already held in this kind of contract provision is a litigated case under the town decision. The town decision in this case went back and said that self-funded plans could not subrogate against others, right? So the appellees in this case have stated that there's no retroactivity issue here, or that retroactivity should not apply. Well, we find that the only argument here today, or really the only question to the court is whether retroactivity applies or not. Okay, that
Help me though, in the process of this case, your client had already agreed to pay the subrogation.
Yes, but that's the same as what happened in Towns. Towns also paid the subrogation.
And your case was concluded before Towns was handed down by the Supreme Court.
We didn't have a previous case.
Well, your cause of action was concluded. Your client agreed to pay the subrogation expenses back to the hospital, right?
Under a contract of adhesion, but yes. Which is the same.
I'm not here to argue about it. I'm just trying to get the facts. So your client agreed to pay back the sum of money under subrogation.
Yes.
It was a negotiated settlement, right? It was less than what was initially.
Not for Miss Whitney. For her husband it was, but not for Miss Whitney. Not for Amy Whitney. And the reason I answer it that way is because in Town, the Supreme Court noted regarding their subrogation that it is a breach of contract claim within the policy if we're going to subrogate monies under a contract provision that we find unlawful. That is specifically what the Supreme Court said in Town and allowed them to actively apply to the previous 5 years for anyone who fell within the statute of limitations. The general rule here on retroactivity and application is whether or not how a new case is implemented. This wasn't an overruled case. The appellees like to state that the Supreme Court overruled Sloan. That's not it. They did overrule Sloan, but they start with saying that the plain language of the statute and the regulations say that it is meant to protect employees, not employers, and they never understood why anyone would ever deem it as an employer. And Sloan was a Court of Appeals case, not something that went to the Supreme Court. And the Supreme Court noted that nothing was should have been set as precedent in this case until the Supreme Court actually heard that appeal in towns when they overruled it. So it was not
So Sloan had no effect?
on.
Be careful, counsel.
Well, no, I'm not saying it had no effect.
Because it was the law in place for 30 years.
It was, but the Supreme Court noted that this was the first time they were interpreting the statute. This was the first time they were ruling on it. Sloan was governing at the time, but they're saying that it wasn't merely an overruling of a case. It was the plain language of a statute that was being applied. So it was not a new law that was being issued. It was a new interpretation that was being governed there.
Counsel, I'm going to go back. You said that then the town decision could be applied. I think you said retroactively to 5 years preceding that decision. But that just means that anyone who hadn't filed a case up to that point, who had a live case under the statute of limitations, could file an action and would have the benefit of town as the decision that was then the governing case law. That's no different from any other decision, is that?
Well, and that's what the Supreme Court speaks to in Hall. Our case was within that time frame. Our case was within the statute of limitations.
But the difference, at least in my view, the difference seems to be that the case, could have been brought, but the case was settled and final, or the dispute was settled and final before town. So it, that case could have been litigated, but it wasn't. It was settled and final. Does that mean that any case that was settled and final within that period gets the benefit of a decision that's handed down potentially years later?
I would say yes, and I'm going to answer your question twofold, if I may. First, the facts here are no different than town. Town also settled his case. Town also negotiated a settlement that went. If that were the case, if we weren't saying if we were saying that was a settled case, then they wouldn't have been able to apply. Then the Supreme Court would have kicked them down for saying you don't have a case. You settled a case. You negotiated a claim. You paid back a subrogation. That was all done in towns. It's actually noted in the opinion that they reimbursed the plan because under these plans, I can't pay out my client who lost their job because of this and the other was off for some period of time. I can't give them the insurance monies they've received until I've repaid the plan, right? So I don't have an option to sit here and say, let's litigate this and let's wait a couple of years and see what happens. We're forced for our client's behalf to pay back those monies before we're able to give that money to our clients, right? So the second part of that is, and sorry, will you repeat the second part of your question? About
my question was, do we, under your argument, does that mean that any case that has been final during the 5 years before town was decided, that any of those cases can be reopened and relitigated?
I would say so, because under Steck-Schulte v. Jennings, the court has laid out, which is really the governing rule on retroactivity, has really laid out that it applies to cases pending on appeal and also future cases. Now,
right,
future cases is not defined as an injury that occurs after the opinion is decided. Future cases is seen as a case that could still be actively litigated, a case that could still be filed. Miss Whitney is within her 5-year statute of limitations. That's why.
Do our rules of preclusive effect not have any effect in that regard once a case has gone final?
I would say that if it would, then in fact, under the doctrines, it talks about an actual judgment that's been filed. and verdict that has been filed. Those are the two that cannot be appealed on a retroactive position. If there's a verdict and a judgment out there on it, neither of those exist in this case. A simple us mailing a check in to pay a lien off is not, to me, something that could be there. And to that point,
So let's take this a little bit differently. Let's take town out of it. I want to talk about a few years ago, there was a cap on non-economic damages that was for $250,000. That cap has been moved and now held unconstitutional in some respects. If cases were settled before that cap changed, say for $250,000, because that's what they thought that the cap would be, does that mean that all of those cases, upon the change in the law, that all of those cases can be relitigated under your analysis?
I would say it depends on that settlement. Was it an active court case that then had some sort of a stipulated dismissal, which would be considered a verdict? Or was it something that was a settlement document that was signed by the parties? Neither of those apply in this case. There was no settlement document. There was anything.
Well, there had to be something for you to pay them money.
They sent us a lien and said, mail us a check. Those were listed.
Negotiated the amount, right?
We attempted to. It didn't. To that, I want to speak on something there. After the work on this case, KU actually filed a lawsuit in Leavenworth County against our clients to recoup monies for what they were saying was money owed under one of the previous liens in Leavenworth County. And so I find that very interesting because we were able to, we counterclaimed it, we fought it. It was a debt collections. KU says, well, one hand wasn't talking to the other. My point on that is if the analysis of the court is that a contract was binding and a contract was settling, why did KU ever file that lawsuit? KU doesn't file that lawsuit in Leavenworth County if they believe they had a final binding contract, a final binding settlement. It wouldn't have existed. So that actually happened later after the case had already started.
Is that part of the record, counsel?
It's not part of the record because it happened after. I do have the case number that I can bring up on rebuttal if you may.
Is that an ongoing case?
No, when we pushed back, the debt collection attorney backed off and we finalized it that way.
It strikes me that it's perhaps an interesting anecdote, but it's not something that we can take into account. It's not part of the record on appeal.
And I understand that. And I'm not trying to do it for that mere case, but I find it interesting that, KU wants to argue that there was this contract and we had this final negotiated settlement, but then they're able to go back and sue, but we're being told we can't from their perspective. That's really the perspective I'm making there.
Counsel, I see that we're at the end of your opening argument time. Are there any other questions from the panel right now? All right, thank you very much. You still have your rebuttal time.
Good morning, Your Honors. May it please the court. As the panel's questions during the appellant's arguments made clear, the relief that the plaintiff is seeking in this instance is the broadest retroactive application of the town decision that could possibly obtain. And that broad application is not one that has ever, to my knowledge, been applied by a Supreme Court or a Court of Appeals in the state of Kansas. They're not asking for retrospective application or retroactive application to the parties to the town case. They're not asking for retroactive application of the decision to parties who had cases pending at the time that town was decided. Instead, they're asking for retrospective application to anyone who is adversely affected by the allegedly adversely affected by the subrogation that was obtained by the plan against their third-party tort recovery. None of the cases plaintiffs have provided this court have reached that conclusion. Every case they have provided with respect to retrospective application has limited such application to the parties to the litigation in the overruling case and parties who had pending lawsuits at the time. The standard for determining whether or not, even assuming this court were willing to branch out and adopt the first of its kind general retroactive application, the standard is not the rule for prospective only cases that is described by the plaintiffs in connection with the Unruh decision. Instead, it is the factors that are laid out in the Sharp case and the Vaughn case. And under those factors, it is clear that what the relief the plaintiff is requesting is inappropriate. Specifically, in courts considering whether or not to apply cases retrospectively, evaluate a number of factors, including reliance on the prior law. Here, there is no dispute that there was 30 years of parties, including the plaintiff and defendant, relying on the Sloan decision as the binding legal authority that permitted the plan to subrogate against third-party court recovery. Courts also look at the adverse effect of a retroactive application. This court is obligated, as the plaintiff has stated numerous times in its brief, to accept as true the well-pleaded facts in their petition. Plaintiffs, while seeking to represent a class and pursue the claims on a class-wide basis, have pleaded that there are an unknown number of people who might be affected by a retrospective application as they request. This means that there could be hundreds, if not thousands, of lawsuits that arise if this court retrospectively applies the town decision to the universe of people who may have been affected by subrogation over the period of time that was permitted pursuant to Sloan.
Ms. Tucker McCovey.
Yes.
Can I ask you, I mean, at the most base level, the language of the law did not change. And so your position is that this was a new law, or that town created new law. And then once we get to that, then we get to, whether it should go prospectively or not. But the fact of the matter is the actual language of the law never changed. And as opposing counsel stated, this is just simply a different interpretation of the law. And it's the first interpretation by the Kansas Supreme Court. So how do you overcome that?
Well, we first dispute plaintiff's contention that this is not new law, obviously. However, it's not a necessary, we don't have to make that finding to avoid the type of retrospective application that the plaintiff is seeking. That standard, the new law standard, only applies when the argument is prospective only. So here, for example, this court could decide that the town court's opinion applied prospectively to new cases filed and arising after the town decision, and the party litigants to the town case themselves, and anybody who had a case pending at the time. That finding does not require or does not necessitate you to conclude that there was new law resulting from the town decision. That standard is only required if we're seeking prospective only application. The other remaining factors that are described in Sharp, frankly, argue in favor of not applying the broad retrospective application that plaintiffs are seeking. And we discussed that at length in our brief. But nonetheless, it is our position this is new law. For 30 years, the parties were operating as though this was, crystally clear, permitted because of the Sloan decision. Also, it was an integral part of the contract between the plaintiff and the defendants. In the record, you can see in the plan documents, it describes how the right of subrogation is a vitally important component of an employer-sponsored health plan. What it does is it permits the plan to offer benefits to the largest majority of participants because it protects the cost of operating the plans from increasing. What plaintiff is asking is to create a special class of individual members of the plan who happen to have been injured and happen to have needed medical services by virtue of third-party tortious conduct. And plaintiff is advocating that those folks should get preferential treatment and be able to recover twice, once under the plan and once from their third-party tort recovery.
Counsel, it sounds like you're wanting to relitigate town.
I don't know that we need to, Your Honor, because I don't think, as we've argued, that it applies retroactively. But, would my clients disagree with the outcome? Yes. We think it inconsistently decided the case with the legislature's intent, which the legislature clarified by enacting the House bill afterwards. And while we don't need to relitigate town today, we can take into account the adverse impact on the plan participants who are not in this special subset of folks, because those are the people that will be harmed if the retrospective application is permitted. They will be the ones that will be subject to having less money available in the plan to cover all of their health insurance benefits by virtue of potentially having to return monies that were obtained through subrogation.
But we don't typically decide whether something is prospective or retroactive based on kind of policy decisions as to who it's going to be affected or who's going to be affected by that decision. Instead, we just decide, based on these factors, is this decision one that should be applied broadly to all cases? Or is this a decision that is just applied basically going forward to the current litigants and to other litigants who are in the process of arguing their case or going forward, right?
Well, I don't disagree with your characterization entirely. I would just point out to the court that the factors that are cited in the Sharp case include the nature and purpose of the overruling decision, the party's justifiable reliance on the law as it stood before, the vested rights of the individuals who are involved in pursuing subrogation, and the adverse effect on the parties and the administration of justice in the event that the case is retroactively applied. So I think it does permit this court to consider the adverse effect on the parties who are harmed by the retrospective application of the town decision. In short, our position is the district court got it right, but you with your unlimited review are entitled to apply the factors in Sloan and reach the same conclusion, or alternatively find that the opinion should apply prospectively only. We believe that this court should affirm the district court's grant of our motion to dismiss, and we appreciate the court's time. If there are no further questions.
Other questions from the panel? All right, thank you. Counsel, I believe you have 5 minutes that you've reserved for rebuttal.
Thank you. And I'll briefly touch on some of the statements made by opposing counsel here. When we look at the perspective only application question and whether that is deemed there, when the Supreme Court has used perspective only application, they've listed it in the decision. They've explicitly said this is a perspective only application of the law. This is only going to affect others.
They did not do that here.
And they did not do that in town. So for it to really only apply prospectively, why wouldn't they have said it here? And I think that's the crux of a case here. The district court erred when they ruled on this because they believe that silence meant prospective only, but there's nothing in years of case law that says prospective only application is the general rule, is what we default to. So I note that. And actually, within Hall, Casco is cited, which changed was a different interpretation of a workers' compensation law. And in that case, when it was the first time on appeal for the Supreme Court, they interpreted a statute for the first time ever. They even noted within the appeal, and as it's noted in Hall, it did not establish a new law and was not limited to prospective application, which is what was applied in Hall to then go back and predate using essentially stating injuries that occurred within that statutory time frame. If it was still a case that could have been litigated, it could have been and should have been and would apply to the new Supreme Court ruling. I would also note that in Stetschulti, there's a couple factors that we see as they come down, and we see in Appellee's brief how they argue against it and saying that the court dismissed the two arguments in Stetschulti. But before the court ever got to that point, they noted that the application should still go to cases pending on appeal and also future cases. Now, I will agree with the court that there's not a very clear or dictionary definition of what a future case would be. I think we are running into issues of straining interpretation of what would mean within the statute of limitations to limit people who actually have a case that they can still be brought. Now, I'm not saying that the court should allow filings from 20 years ago. And in fact, I think
Are you arguing then that every single case that involved a subrogation lien over the last 5 years can be reopened?
I think that the town's court spoke to that. They said there,
Once those cases have gone final. So all those cases that have gone final between 2000 and when was town? So
24.
yeah, so from 2019 to 2024, all of those cases that were settled, all of those cases that were litigated on the merits and went final, all of
No.
those cases can be reopened?
No, because under the rules of how the Supreme Court applies those to retroactivity, anything that has a final judgment, anything that has a verdict attached to it is done. They say that. There's nothing that says that a settlement would not be done in that case. And I think it's even a stipulated dismissal or something of a case that's settled within court, I believe would be deemed as having a verdict, so that couldn't be relitigated. But the subrogations that happened within those 5 years, yes, I believe that applies with as a future case because you have it. Now, I would argue that it's from today's date back to 5 years. Those cases could have gone with towns, but if it was a middle of 2019 years, they'd be out of the statute of limitations now. I note that because in the motion to dismiss, there was some questions raised by appellee, but that under our interpretation, we'd be saying we could go back 30 years to relitigate every case, and that's not what we're saying. We're saying cases that can still be litigated that are within the statute of limitations would require us to be able to utilize them. And I state that because if the court didn't want us to handle it that way, then they would have applied prospective only application as they have done in Carroll v. Kittle and many of the other cases that the appellee cite. They specifically list prospective application. They did not do so here. And I would, to the further point, I want to bring up the legislation over just a couple seconds that was pushed by the defendants here. If the legislature intended for it to not be retroactive, they would have made that statute retroactive. The legislature can always make a statute retroactive. They did not. They made it pursuant to July 1 of 2025. If they wanted that to be retroactive and say, this question isn't for the court, here's our intent, they could have gone back and said, Towns was wrong, we're going to make this so that it's from January 1 of 2024. They didn't. As we're fully aware, the legislature can always make a statute retroactive.
Well, within reason, there are
Within reason.
limitations on that ability.
Within reason, but even if they had said January 1 of 25, something, they didn't put any retroactivity in their statute whatsoever. So I note that because we're talking about legislature's intent. I don't think the legislature intended for any of that to happen until after July 1 of 2025. So thank you.
Opposing counsel talked about potential economic harm to current plan participants. Should that factor into the decision that we make?
I don't think so, because when we talk about unjust and hardship, first off, any of those decisions could have been made by allowing us to make it through a pleading stage, right? This was kicked out on a motion to dismiss and not further down the road on a summary judgment or something, because how many plan participants have been affected by separation? How many plan participants are in the same situation as my clients that could have been recovering money? They could be in a more, it'd be placed in a worse position than even that plan. And quite frankly, I think that's the hardship and injustice that's being applied. Does that answer the question?
I think so.
If there's any
Questions from the panel? Would you like to close or are you finished?
I've taken enough of your time, so thank you.
All right. Thank you very much. Thank you, counsel. We'll take the matter under advisement. I want to thank you for your excellent arguments and for your excellent briefs. We'll get a decision out as soon as we're able. And at this point, the court stands in recess until 1 o'clock this afternoon. Thank you.
Say Guyer when I first got here.
It did.
Okay.
He had to recuse himself.
Check 1, 2, check.
It was a little off how it was noticed because it was like 9:30, 1:30, couldn't find our case. And 1 o'clock, worked at something.
Judge, and I'm recusing.
Right. Is that off?
What does the red light mean if it's on?
It's on. It's not getting recorded yet, though. It does toggle off if you want it off.
No, it's just, it's a hot mic, but it's got a red light on.
Red is good in this case.
Okay. Mound City was bad. I was hearing myself 3 times. So still kind of regret it. Sit down.
You're the only one thinking about.
Okay, traffic solutions. Here, on the right.
Yeah.
All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Kansas is now open. The Honorable Sarah E. Warner presides.
Welcome, everybody. Please be seated. Want to welcome everyone to the July 2026 oral arguments before the Kansas Court of Appeals. My name is Sarah Warner. I'm the Chief Judge of our court. And I'm joined today by a distinguished panel. To my right and your left is Judge David Bruns. Judge Bruns was appointed to our court in 2011 after serving on the Shawnee County bench for many years, of course. And to my left, your right, is Judge Kim Schroeder. Judge Schroeder was appointed to the Court of Appeals in 2013 after serving almost the exact same amount of time as Judge Bruns, only in Stevens County in Huguenon. We will be hearing one case this afternoon in special session, and after that, we're going to recess and do some changing of personnel and come back for our normal 1:30 docket.
That means I get to leave.
In preparation for today, we have thoroughly reviewed the record. We reviewed the briefs. We have also reviewed a legal memorandum that's been prepared by a research attorney. So we are very familiar with all of the facts that have given rise to this case. And so we encourage counsel, you've got 15 minutes, just jump right in so that we can get to the meat of this discussion. And with that, I'll turn to the case before us from Shawnee County, case number 129054, Kansas Highway Patrol appellee versus Justin Dobler, appellant. Would the parties please state their appearances?
Alan Johnson, I'm here for the appellant, Mr. Dobler.
Yeah, please court, David R. Cooper, Crystal Moe, and KHP General Counsel Luther Gagne for the Highway Patrol.
All right. Mr. Johnson, would you like to reserve any time for rebuttal?
Yes, I'd like to reserve 5 minutes.
5 minutes are granted, and with that, you may begin.
As the court knows from reading the briefs, this is an appeal or a review from a district court decision from Shawnee County, reversing a decision by the Civil Service Board, which had decided to reinstate Mr. Dobler to his employment with the Highway Patrol after he had served a 1-year suspension with no pay. Now, the main issue I want to focus on today is the fact that in reaching that decision, the district court took judicial notice of 16 facts that were not contained in the agency record. And it's my contention that the district court erred in considering those 16 facts, and that this court, under its scope of review, which is the same as a district court, should not consider those 16 facts. And I want to briefly—
Johnson, let me talk a little bit about standard of review. As you and Mr. Cooper both know, we're really bound by the standard of review. And I think you just said the appropriate standard of review, but I just want to make it clear. We're really reviewing the Civil Service Board's final order and not necessarily the district court's order, because our review is the same as if it was appealed directly to us. Is that accurate?
Yes, I agree with that. And towards that end, the 16 facts that the district court relied on are not in the agency record. And therefore, my position is the court should not consider any of those facts because they all related to the State versus Klein case and to a wrongful death case, both of which arose long after the Civil Service Board hearing. They didn't rely upon that. It wasn't even before them. Many of the facts didn't exist in that point, and therefore those facts should not be considered. I agree with you, Judge, that you should look at the record of the Civil Service Board. You're reviewing their opinion. They had a very long, lengthy opinion with many findings of fact, and the real question is, are those findings of fact that the Civil Service Board made supported by substantial competent evidence, and is their opinion reasonable? And my position is yes.
counsel, just coming back to that, because this is, as you pointed out in your introduction, this is an interesting case because it's an appeal of an appeal of an appeal of a decision. So are we ultimately reviewing the Kansas Highway Patrol's decision? Or are we reviewing the Civil Service Board's review of the KHP's decision? What are we reviewing?
You are reviewing the Civil Service Board's decision. The Civil Service Board is a little bit different than many agencies in that it, once an appeal is made to the Civil Service Board, they become what's called the appointing authority. They're the ones who decide what discipline should be meted out to an employee. And they have,
But their review is limited.
they have very broad power to make decisions on, they can substitute their decision for an agency.
Didn't the Supreme Court in Denning say that that review is actually a reasonableness determination? It's not an unlimited determination.
Well,
They just had, they can only review and reverse and change the agency's, the originating agency's determination if that determination was unreasonable.
correct. And that's what the Civil Service Board found. They found it was unreasonable based upon their view of what the discipline should have been. They raised some issues about the decision-making process by the Highway Patrol. They thought that some of the decision-making was suspect, and they thought that overall that the penalty of dismissal was too severe and that a more appropriate remedy, which they're able to do, was to suspend him without pay for 1 year.
Do you agree that Denning, even though I know it wouldn't be necessarily binding on this case, that it's persuasive to us just based on the language in the decision that relates this? I mean, that was a county sheriff's case, if I remember right.
Yeah.
But I think the standard would be the same, at least that would be your position.
Yes, yeah. I think the standard is what was the decision by the Civil Service Board reasonable, and was it supported by substantial competent evidence? But
I bring that up because as I'm sure you can tell, the standard of review is everything in this case, right? And so in looking at who is the decision maker, to what extent, where, and often when we are talking about a reasonableness assessment, we are saying, we're not substituting our judgment for what should have happened. We're just saying, was that decision one that was not unreasonable, right? And so is this different? Is this assessment that the Civil Service Board doing, or that the CSB did, is that a different assessment than our normal reasonableness review?
no, not from looking at what the Civil Service Board did. I think it's the same and normal view. Now, the Civil Service Board, though, in looking in overseeing, deciding what the agency did, they have the right under the statute to modify or change whatever that decision is. As I said, essentially, they are the appointing authority. Then the question for you and for the district court is, okay, well, did they have a reasonable decision? Is it supported by the substantial competent evidence? Is it reasonable, or was it arbitrary and capricious? And I submit that it was reasonable in that they carefully went through all of the evidence. It's a 19-page opinion, I think, single-spaced. They analyzed a variety of things. It was not an easy case, but they were very careful in going through that. And I think this is a close case. The Civil Service Board split 3-2, and they disagreed with what the Highway Patrol did. So again, I think that neither the district court nor you should substitute your judgment for what the Civil Service Board decided, because under the statutes, the legislature said we want the Civil Service Board to be making those decisions where the employees are classified employees and have rights to employment. And so that is different than their review is different than you. I agree with you. Your review is, was it reasonable, supported by evidence, or was it arbitrary and capricious? And I don't think that you can say that it was not supported by substantial competent evidence, because they went through in great detail what the testimony was. They had 3 days of hearing in which they heard a number of witnesses. They assessed those witnesses. They made their decision. And I think that the Civil Service Board, in looking at all of the evidence, they carefully went through all of the evidence. It's a 19-page opinion, I think, single-spaced. They analyzed a variety of things. It was not an easy case, but they were very careful in going through that. And I think this is a close case. The Civil Service Board split 3-2, and decided that some punishment should be meted out to Mr. Dobler, but that dismissal was an unreasonable discipline for them. And that's really what you have to decide. Did the Civil Service Board's decision to modify what the Highway Patrol did, was that a reasonable decision to modify that?
I want to make sure I understand. It seems like both sides agree that there was at least some, you're not challenging that there was at least some violation. I'm sure your client may personally challenge it, but here in this appeal, you're not challenging. You're basically asking us to reinstate the Civil Service Board's order.
Right.
So both sides at least then would agree that there was some type of policy violation, at least for the purposes of our appeal. And it really comes down then to whether or not the Civil Service Board could replace its judgment for that of the Highway Patrol when it comes to the remedy.
Correct.
And I know there's language in the statute that says that they can modify. What's that mean?
I think if this court interpreted that gives them very broad powers to modify a decision, employment decision, to what they think is reasonable and appropriate under the circumstances.
If we're reviewing it like they did, can we modify?
No, you have a more strict. Yours is just asking, is it reasonable, supported by substantial competent evidence?
So did you find any cases out there, and Mr. Cooper, I'll probably ask you the same thing. Did you find any cases that would help us understand what modified means? You know, to me, modify means is kind of let's change a little bit. But this seems to be almost of, hey, we recognize your judgment. We don't like that. We're going to just do something entirely different. Have you found any cases that help us understand?
Well, the one
just use plain language.
One case I cited was a decision by this court in which you said the power was very broad. Didn't really delineate more than what it was, but broad powers would indicate, I contend, that you can modify, and it's not simply just affirming or reversing, it is modifying, which is the language that is used in the statute. And that means
what needs to be found in order to modify?
An unreasonable decision by the agency.
And is an unreasonable decision a decision with which you disagree, or does it have to meet some higher standard?
Well, in this case, I think the Civil Service Board, because they are the appointing authority, once the appeal is made to the Civil Service Board, the appointing authority is not the agency, it's them, and they have the right essentially to make a decision on what the appropriate discipline is.
And I think, I mean, you can see where our difficulty is here. If under Denning, that review is a reasonableness determination, what does that, because that seems like a narrow view, right? Like a reasonableness determination, that was Kansas Highway Patrol's decision reasonable or unreasonable? And the CSB agrees, or at least accepts the facts that were found with regard to the violation. They just disagree with the ultimate outcome. Is that a reasonableness determination, or is that just substituting the CSB's judgment for that of the Kansas Highway Patrol?
Well, to some extent they can. Again, I go back to the term modify. I think they can in some ways substitute their judgment because they are the appointing authority. And so the question becomes, under all the circumstances, is do they find that the Highway Patrol was not reasonable? And I think they did. It was not, like I said, it was a very well-reasoned decision and justified. And so you would have to find that was an unreasonable, or it was not supported by substantial confident evidence, or it was arbitrary and capricious.
Or it was taken in, or it was a decision that was reached that was beyond the scope of that review.
Correct. You could find that, yes. And the remedy would be, if you said, well, Civil Service Board, you went too far, would be to remand it back to the Civil Service Board with whatever instructions you think should be given to them, because in the first instance, they are entitled to make a decision based upon what ultimately you decide they should or should not have done.
Counsel, I think that we have
we've helped you exhaust your time.
Right. But you have reserved 5 minutes for rebuttal, and we will look forward to hearing from you unless there are other questions from the panel. All right.
Okay, thank you.
Counsel, this is a fascinating case.
I don't disagree with you. And there are fingers that extend well beyond the bounds of this decision. To address your first question, yes, this is a review of a review of a review of a decision made by the Highway Patrol. And we start with that it was the burden of the appellant, Justin Dobler, before the Civil Service Board to bear the burden of showing his termination was unreasonable. Now, I also agree that the Civil Service Board made the finding, it's in the black and white, they said termination was unreasonable, but they don't tether that to any facts. And on page 31 of the KHP's brief, we use the dictionary terms of unreasonable. It's like, all right, so how did the CSB conclude that the Highway Patrol's decision to terminate Justin Dobler did not reflect good judgment, was irrational, capricious, or an unreasonable decision?
Counsel, reading between the lines, it looks as though the CSB was troubled by the fact that there was this policy, but there was a conflicting potential policy from this Operation Frontier Justice, and so it looked as though they thought it was less black and white than the KHP perhaps found.
And I think they found shades of gray where there aren't any, and that's okay. In terms of the messiness, again, don't disagree with that. This is messy from the beginning. Justin Dobler, I mean, when you get way down in there, started working for the Shawnee County Sheriff when Herman Jones then was the Shawnee County Sheriff. He had problems with pursuits then, and while under the shades of a grieving discipline related to a pursuit, he took employment with the Highway Patrol long before Herman Jones became the colonel. He has a problem with pursuits in the Highway Patrol. He eventually gets told, stop getting into chases in Topeka. And that's the issue that the Civil Board found conflicting in terms of he had been told, quit getting into chases in Topeka, but he was then assigned to the Frontier Justice Marshal's task force, which suggested maybe that order does not apply to him, but the command in that is you are still subject to your agency policies. That gets us back to the black and white and not the gray, which is the agency policy, which is what the Civil Service Board agreed that Mr. Dobler violated OPS 16. He violated the pursuit policy. And the one finding that the CSB did not sustain was the finding that he had violated the direct order. But he did violate the OPS 17. He did kill somebody. Those are facts. And we'll need to address the judicial notice of some of those facts. But the CSB found his term.
Well, do we? If our review is of this final order, what difference does it make with I love district court judges. I know Judge Schroeder does as well. But
I also love district court.
Good. But what difference does it make? We don't give any weight till that decision. Don't we go back to the CSB's order?
Short answer is yes, and it doesn't matter.
That's my thought. So here's what I think, and everybody agrees there's a violation, at least one. Now, maybe Mr. Or Officer Dobler would disagree personally, but as far as this appeal, we have to, agency policy OPS-016 was violated. So we have to start with that premise. And it looks like the only thing that's really in question is whether or not the KHP's decision to terminate was reasonable or not.
Agreed. And against that background, against that decision, and that's why I talk about the judicial notice of all of those things. The judicial notice really isn't a judicial notice of any new facts whatsoever. but rather it's shining a really bright light on what the impact and the conclusion you must draw from these facts really is, which is the facts were already in front of the Civil Service Board and they agreed with them and they found Justin Dobler violated Ops 16. He killed somebody in the process of doing it. When presented with his proposed termination, his response to that was, I didn't do anything wrong. And then he doubled down on that when he took the oath and testified in front of the Civil Service Board and said, not only I didn't do anything wrong, but if I had it to do over again, I'd do the same thing. So knowing what already happened and presented an opportunity to do a mea culpa, he says, if I had to kill an innocent person again, I'd do it. And I'd like you to give me a patrol car so I can do it again. That was the decision faced by the Highway Patrol and presented with his response to what do you think we ought to do about the fact you violated these rules? His answer was, I'm going to go do it again. Well, when you're presented with a decision with somebody who says, I'd like you to give me the tools to go commit constitutional violations, the only decision that the command staff could make is, then you don't need to work for the Highway Patrol anymore.
What about Mr. Johnson's argument? And it is based on the statute that says that one of the remedies that the Civil Service Board has is to modify.
I agree with that too.
And
that's what it's.
What's that? And you heard my questions to Mr. Johnson, but what does modify mean in this context?
Well, of the menu of options that were available to the Highway Patrol, it was do nothing, reprimand, suspend for up to 30 days, or terminate. And so their menu of options to modify the discipline was to, well, if termination is not appropriate, then the most that can happen is a 30-day suspension without pay. And they didn't find that was appropriate either. And it is not a boundless, go make up your own remedy of authorization. All of this has to be within the framework of the Civil Service Act itself. And when the Civil Service Act says the appointing authority has these options and no more, those are the options available to Civil Service Board as well.
So them choosing to exercise a 1-year suspension, does that make their decision arbitrary?
It does. And I am asking for a remand to send it back and say, leave the termination in place, because a decision that anything other than termination is eminently unreasonable. That's what I'm asking. That's what I asked for in front of the district court. That's what I'm asking for from this court as well. Why? Because Judge Brunn's getting back to your question. If they could fashion anything they want for this case, one of the appropriate things would be, well, we're going to discipline you and make sure that you can never drive a car again and do this to someone else. That's problematic in that that's not one of the menu of options. He's in the classified civil service. At that time, he was a trooper, so there's no non-trooper position to reassign him to. So reassigning him to a position where he can't kill somebody would be what we're trying to accomplish. Well, we can accomplish that by telling him, you come on shift, you do 5,000 push-ups, and if you can still lift your arms after that, then maybe you can go patrol the highways or something. In other words, do it so it's impossible for him to kill somebody. That's not a menu. That's not a reasonable option either. So the options that were available for the Civil Service Board to modify the punishment is to remove it from a termination down to a 30-day suspension. And they clearly said that that wasn't enough.
They found something in between. It does seem like that, in addition to what Judge Warner indicated, that the board was concerned with what they call an unusual way in which the review was handled internally. And it was a little unusual in that some of the supervisors went back and modified the reports. And they also seemed to put some weight on the fact that he did not lose his law enforcement certification, and that the Shawnee County District Attorney had not filed charges against him. Are those things enough to support their decision?
The
The
fact,
termination was unreasonable?
short answer, no.
And why? I figured you'd say no. If you said yes, we're done.
So the longer part of that, the fact that another agency does not decide to press charges. The fact of the matter is the KLETC or the C-Post never actually initiated any investigation. So their decision not to take action was not based upon a review of the facts.
What CPOS?
Pardon?
CPOS, what is that?
Kansas Commission on Peace Officer Standards and Training. They're the ones who grant and decertify law enforcement officers.
I thought I had it right, but I just want to make sure.
Too many acronyms.
Right. So yeah. So him saying that C-Post didn't pull my certification. Okay, they didn't open an investigation. They didn't. That's a discretionary function to C-Post. That doesn't mean it's a reason. Well, they certainly didn't bless what he did. The decision of the prosecutor not to charge him with a crime, again, prosecutorial discretion, we don't control that. What we control is whether we're going to give Mr. Dobler another car to go kill somebody else. And at the time those decisions were being made, that was before Judge Pickering made the decision and made the actual finding that it was a Fourth Amendment violation, applied the exclusionary rule. They went up through this court, review denied by the Supreme Court.
Do we even need to get into that? I mean,
Yes.
It was subsequent. It seems like your argument is that the decision of the Civil Service Board should be reversed regardless of all these additional things that happened after the
Right. All I'm saying is that Judge Pickering's decision was a flashlight.
It's a Fourth Amendment violation. We deal with Fourth Amendment violations a lot, and we don't terminate every officer that commits a Fourth Amendment violation.
not-
Nor do we even exclude the evidence.
Not even every
In every case.
violation is the result of killing an innocent.
But that was already in the record. That was already in the record below. We already knew what maneuver he did, where it was at, the trailer park, all of that. Passenger in the car dies. We knew all that. We really don't need all this other stuff, nor do we need to look at it since it was the district court, and we review it as if the appeal was brought to us directly.
I'm still agreeing with you.
Okay.
On that and saying-
Well, I'm just wondering why we even need to consider. I'm sure Judge Malone did a nice job, but why consider that opinion?
Didn't the car chase start over a broken windshield?
Cracked windshield. That was it.
Or cracked
And he
windshield?
never had more cause other than the fact that they ran from him and he started trying to pull him over. So again, in terms of that gets into the heart of OPS 16, which is when you start a pursuit, you are required by policy to constantly evaluate, one, the decision to start the pursuit, and two, to continue the pursuit and weigh the benefit to the public versus the risk to the public by continuing that pursuit. And here,
Counsel, we keep talking about the facts and we acknowledge there was a violation. So here's what I keep coming back to is ultimately this standard of review question. What is our standard for determining whether the CSB properly exercised its authority when that review was a reasonableness standard? What is our standard to determine whether that decision was in fact exercised within its appropriate authority?
hard questions by associates. The answer is almost always, what does the rule say? The rule here is, did the CSB erroneously or interpret or apply the law? Was their decision lacking in substantial evidence, and was the CSB's decision unreasonable? And one, Colonel Jones' decision to terminate Dobler was reasonable. It was not unreasonable. Their conclusion otherwise. And coming back to Judge Bruns's question and the deal about all the facts is the idea that reinstating Justin Dobler is unreasonable because it ignores the enormous dimensions of his admitted behavior, which you say are just the facts. Well, those facts are so significant and so important that any decision other than termination is by definition unreasonable, arbitrary, capricious. That's why I'm asking you to remand it and that with directions to the Civil Service Board to affirm the dismissal.
I do want to follow up, just make sure I understand. If they were going to modify, it's your position that there was a menu of options that they could do, and they just could not create out of whole cloth their own remedy. Is basically okay. And what were those options? Termination and 30-day suspension.
30-day suspension.
Any other options?
Reprimand and do nothing.
Okay.
Any other questions from the panel? All right, thank you, counsel.
Got all mine.
Mr. Johnson, I believe you've got some rebuttal time up here with us.
Judge, I just want to follow up again on the scope of review, which I agree is a difficult question to decide, but the statute, which is 752929 DB, not only uses the term modify, it also says that the board may order any other action it deems appropriate. And as the decision I cited in my brief in the Del Sadio case, this court said that's a very broad grant of power. And so that's what they did in this case, is they decided to modify it and order what they deemed to be appropriate. So then the question becomes, okay, is that
case, why include a menu of options in the statute?
a menu of options for what?
For potential outcomes for the CSB's decision.
Well, I think those were not limiting ones, but maybe more examples, because the power is broad. They can modify or order any other action they deem appropriate. That's pretty broad.
Usually when we hear language like that, we think that includes like catch-all, potentially like equitable relief, it fines, costs, et cetera. Does that mean it appears that your argument is it basically nullifies all of those menu of options? They can do whatever they want.
Well, I would say that my position is they have broad discretion under that decision. So really, did they abuse that discretion? Was their decision so far the mark that no reasonable person would take that? And that would be the standard I think you have to look at, which is a difficult standard to overturn. What the Civil Service Board has done is that they acted unreasonably, meaning that they abused their discretion, that they took a position that no reasonable person would take. And
is that different from the reasonableness assessment that the Civil Service Board does? Is our assessment as to whether the CSB's decision was reasonable a different assessment from the CSB's decision as to whether the patrol's decision was reasonable?
I would say yes.
Why?
They have broader authority to provide a remedy. This court can only affirm and reverse. They can modify what's been done. They can order something else that was not done, which under the Judicial Review Act, you can't do. So they do have, my position is they do have broader authority than you do when they review the Civil Service Board.
So they have a broader menu of options, but what about the reasonableness determination?
It has to be reasonable. I'm not disputing that their decision, the Civil Service decision, that the agency acted unreasonable has to be a reasonable position. Meaning, is it supported by substantial competent evidence, and would it be within the realm of reasonableness? That reasonable people could disagree, as the board itself did. They disagreed on what it ought to be. And that's my position. Reasonable people can disagree on what this is, but their decision was not so far wide of the mark that no reasonable person would have accepted it.
So what evidence is there in the record from your perspective to support the finding that, quote, termination was unreasonable, close quote?
Well, the Civil Service Board didn't look at the Fourth Amendment, any of those issues, because it wasn't before them, because most of those things didn't.
Well, I'm saying what evidence is in the record before them to support their finding that termination was unreasonable?
Well, they looked at the policy of the the internal policy of the Highway Patrol, and they said, considering all the policy, all the factors listed in that policy, based upon the evidence we heard, we think that that was unreasonable. And they went through, as I outlined in my brief, they went through 4 different categories in analyzing why they thought the Highway Patrol had acted unreasonably and why they thought their own decision to modify or have a different decision was a more reasonable position. And I see I've used my time. Thank you very much.
Thank you.
This was, as I have indicated, a very interesting case. The court takes the matter under advisement, and I want to thank counsel for your excellent briefs and for your discussion here today. We'll issue an opinion just as soon as we're able. And at this point, we're going to take a brief recess so that we can do some choreography and personnel changes up here, and we'll say goodbye to Judge Bruns for the time being, and we'll be back
I was just a relief pitcher.
to hear the remaining cases this afternoon in about 5 minutes.
Waiter.
We shall see.
You, Alan.
Nice to see you.
All rise. Be seated for now. Sorry. All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Kansas. The Honorable Sarah E. Warner presides.
Welcome, everybody. Please be seated. I want to welcome you all to the July 2026 oral arguments before the Kansas Court of Appeals, and thank you for your patience just now as we did some kind of changing of seats. My name is Sarah Warner. I am the Chief Judge of our court, and I am joined today by two distinguished jurists. To my right and your left is Judge Kim Schroeder. Judge Schroeder was appointed to our court in 2013, and previously, since 1999, he served on the district court bench in Stevens County in Hugoton. And to my left, your right, we are very pleased today to be joined by Judge Jason Geyer from the Shawnee County District Court in the 3rd District. Judge Geyer has served on that court since 2017. We will hear two cases this afternoon. And in preparation for those cases, we have thoroughly reviewed the record, the parties' arguments in their written briefs. We've also reviewed a legal memorandum that's been prepared by a research attorney. So we are very familiar with the facts of all of those cases. So we encourage the attorneys in those cases to just jump right in because we, of course, only have 15 minutes of argument per side. So with that, we'll turn to the first case before us. And that case is from Wyandotte County, case number 129703, in the matter of the marriage of Rachel Hale, appellee, and Scott Hale, appellant. Would the parties please take their positions? And would the parties state their appearances?
Please court, Your Honor, Mark Rohrbaugh on behalf of Scott Hale, appellant. I'm with the law office of Dan Stewart.
Thank you.
Good afternoon, Your Honor. May it please the court. Petitioner appellee Rachel Cooper, formerly Rachel Hale, appears in person and by and through counsel Patrick Johnson of Kansas Legal Services.
Thank you. And Mr. Rohrbaugh, would you like to reserve any time for rebuttal? 5 minutes are granted. And with that, you may come forward and begin.
Please court. Thank you for meeting this afternoon to hear this case. Much like they were arguing in the case before us, I think the standard of review is one of the important elements, and there's disagreement on the briefs of what that standard of review would be, and so I'll spend some of my time with that. But just as a large overview, Mr. Hale and I had a tough couple of months last summer with Judge Albee, where we found a court that was hostile towards not only our arguments, but seemingly to the litigant personally, and made many assumptions about facts that were never in front of her, made many dismissive comments about Mr. Hale, and said things like, that's all fine and dandy. I'm sure that's what he thinks. Congratulating Mrs. Hale and telling her she was sorry, assuming that everything that she alleged had happened was in fact true, when none of those facts were ever before that court. All there were statements of counsel. Mr. Hale was never even present at his own divorce trial. So I come in after the fact, and I've got a simple argument. My argument is due process, procedural due process. Counsel argues that, 2 points, and I agree that it's a notice and an opportunity to be heard in a meaningful way. The notice is not the issue. It's the opportunity to be heard in a meaningful way that I believe my client was deprived. He had a power of attorney that made arrangements, attempted to make arrangements. She testified in court that she called the court a week in advance, talked to staff so that Mr. Hale could be there in person, and that she believed that he would be there. When she arrived at the day of the trial and Mr. Hale wasn't there, she was surprised that he wasn't there. Attempted to address the court. The court wouldn't hear it, wouldn't allow her to talk. You're not an attorney.
Let me stop there. Where is that in the record? Because I reviewed that hearing and I did not see anywhere where she attempted to interject or speak upon Mr. Hale's behalf.
Well, I guess I don't have a page cite in front of me, and it'd take too long to find to be meaningful to you. But it's my understanding from my recollection that that the power of attorney, Ms. Belk, who's here today, was there. And
I know she testified to that, but at a later hearing, but I didn't see where she was there.
At the trial date?
Correct.
I'm not sure if that part was on the record, Judge. I don't know if that happened as part of the court proceedings or if she stood up either before or after a record was made, and I personally was not there. So the record might be silent as to, on the November trial date, as to exactly what Ms. Belk said to the court that day. But her testimony later, when she was called and sworn in, was that she attempted to address the court and was not allowed to.
Counsel, whose responsibility is it in a civil case, once you've received notice that a hearing is going to occur? And I understand the circumstances here and why Mr. Hale was not present, but isn't it still his responsibility to notify the court or to request a continuance? Is it the court's responsibility?
No, Judge. Here's what I would say to you. And the Supreme Court in Matthews says, every case is different, and we need to take a look at the factors in each case and apply the test in this particular case. And in this particular case, Mr. Hale testified to the judge that he did not want a continuance, that he wanted to go forward, and that he had made requests from the jail to go a day in advance.
But not until that day.
Not until that day or day in advance. I agree. Not with a lot of advance. And he testified that he had been brought to all his previous criminal trials, and he didn't know why the civil would be different. But he had also had his power of attorney call a week in advance and request it, and she.
But a power of attorney is not an attorney.
No, but you don't need an attorney to call the judge and request that someone be there before their trial to let them know that they want to be there. I don't think that takes an attorney at law to do that. I think you could have your girlfriend, your wife, your next door neighbor, anybody inform the court that the person in custody would like to be there at their trial. And the court should have been made, or in my understanding, was made aware that he was in custody and wanted to participate. And she just simply wouldn't continue it. She could have continued it for 30 minutes and called over to the jail and asked if they could bring him down, because they're literally in the same connected buildings.
That was my question, is where's the jail in relationship to the courthouse?
They're literally connected. They're probably technically two different buildings, but they are connected buildings. And he was housed within yards of where the courtroom was. So this idea that it would have been difficult or expensive or burdensome in order to get the person there does not apply in this case, unlike some others where they were in federal custody in Florida. We didn't have that. We were in functionally the same building where the trial was.
I'm going to hit on two things you just said. First of all, you said your client assumed he was going to be brought over because he'd always been brought over in his criminal cases.
That's what he testified to, correct?
Right. Assuming that's true, number one, this wasn't a criminal case. He made an assumption. He made an assumption that was incorrect. And this wasn't like a pleading that judges are too liberally construe. When he decided to represent himself, the court could give him neither an advantage or disadvantage by proceeding pro se. The law's pretty clear on that. He decided to represent himself and wouldn't, in some respects, the court be giving him an advantage by ensuring that he either had a continuance or was brought over. I mean, isn't that his responsibility?
And I would say to you, Your Honor, if that were the only thing, is that he asked to be brought over the morning of, if that were the only thing he did, their argument would be much stronger. But the fact that he had someone on the outside with freedom ask on his behalf.
And that's where that was going to be my second question. I hear a lot about this power of attorney, and I know his power of attorney testified at the second hearing, but any sort of power of attorney document I do not see in the record. She says that she called the week previous, but her testimony was, I don't remember who I talked to.
Talked to a woman whose name I did not get.
Right. It's very ambiguous. She said she tried to speak at the actual hearing, but there's nothing in the record that says that other than her testimony. It's all very, at best, it's ambiguous. And so when you say if that's all they had, if that's all the other side had, they may be onto something. But there was this other individual that was, for lack of a better term, advocating on Mr. Hale's behalf. But quite honestly, I don't see a lot in the record that indicates that.
Well, her sworn testimony under oath in open court says that she did it. And I guess if that's about the best evidence I've got to give you, a sworn testimony, Judge. And it does not have to be. Let me ask this question back to you, Judge. Do the courts have an obligation to protect our rights? And yes. Does the court have to go out of their way and spend a lot of time and money to protect someone's rights? It depends on what's at stake, right? In this case, the judge knew the man was in the building in custody, knew that he wasn't there, and was dismissive and did not care and wanted to roll forward with this divorce without any attempt to give him the opportunity to be heard.
Counsel, does the timing play into this at all?
Which timing?
The timing, I understand you went back several months later on Mr. Hale's behalf and asked to reopen the case. And my question, if this were done within 30 days, if the request to reopen it would be done within 30 days, a different standard applies. But after that point, it becomes more difficult. And it looked like Judge Alvey was thinking, well, you're reopening now, basically, as we have an ulterior motive for this determination to attempt to reopen this judgment at this point, instead of just, oh no, I wasn't able I thought that I was going to be able to be there. They went on ahead and went forward. What can I do? Contacting the court as soon as possible after the decree was entered.
Judge, I can't speak to anything before I was there. I got involved with it in the late spring when we filed as first hearing in June. Filed my motion maybe a week or three before that. I don't know exactly, but
but it was over 6 months after the decree had been entered.
I would agree. And 6260 talks about a reasonable time. Some have a year limitation, so it's within time for that. And we are talking about a constitutional right, which may be set aside at any time. And I say that the decree itself is void because of a failure of a due process. And I guess someone could speculate about alternative motives, but that certainly wasn't any part of our argument. It certainly wasn't any part of our evidence. We said the man didn't get in. We filed this motion. Now, between the filing of the motion, it wasn't 6 months. Before it was heard, it was in the vicinity of 6 months. And the property was all still there. It was all still capable of being judged. And you could, because the man just wanted to get in and have his day in court, and that was still available to him. So there wasn't any strategic value, unless, like counsel argues, that the idea is to get over the 30-day appealing of the judgment, but he's not appealing the findings in the divorce so much as he's appealing that the decree of divorce itself exists, and the whole thing should be set aside because of a due process violation.
Well, does the fact that your client filed an answer change the standard for the court proceeding without him being present?
I think it does in some extent, because the court, this wasn't a complete default where the person had never shown up. The person did file a pro se answer and did say that they had problems with the proposed property settlement. It was, it was not a professionally done answer, but I think it qualifies as an answer. And the court was on notice that this person wished to participate, and the person was out of custody when the answer was filed and then was in custody by the time of the trial. And so
Do you know how long he remained in custody after the trial?
He's still in custody today, Judge. He's still in pretrial detention today. There's not a trial on his underlying case, so he's still in the Wyandotte County Jail today.
So he's never been released.
Correct. Yeah, it's pretrial detention. No conviction has been had.
Are there any other questions from the panel at this point?
What's the underlying charge?
You know what, Judge? I honestly don't know. It's domestic violence of some sort with Mrs. Hale as the alleged victim.
Okay, that's the only thing I saw. I didn't know. All right.
Yeah. But I've never looked because it didn't matter to me. All right, and I see my time's up. I will address some of this standard review that I promised in my rebuttal. Thank you.
We'll look forward to it, counsel. Welcome.
The through line of this particular appeal, I think the court has already keyed in on, and that's namely where the responsibility for Mr. Hale's failure to appear at his divorce trial lies. It's the appellee petitioner's position that Mr. Hale had constitutionally meaningful due process notice and an opportunity to be heard, and he merely did not avail himself or invoke the process that the court laid before him. Before I get into—
Well, counsel, how could he invoke that process if he's been held in custody?
Well, he already had invoked that process by filing an answer. He was notified of the case writ large when he was served with the petition. He filed an answer where he offered a nominal response and objection to his ex-wife's proposed distribution of assets, which I think came from his perhaps conversations with her counsel at the time, because there's no reference to that and what her position was in the pleadings. And by the time he was in custody, he testified at the evidentiary hearing last July that he received notice of the trial date while he was in custody. Litigants who are in—
What bothers me about this case is that everyone knew what was going on. Everyone knew that Mr. Hale was representing himself, had filed an answer, disputed the outcome. Everyone knew that he was in the Wyandotte County Jail, and the trial went forward.
Yes, and the Judge Alvey could have certainly in her discretion looked at those facts and said, this litigant is clearly in custody. I'm going to continue the trial, or I'm going to call the jail. She could have done that, but her refusal or her decision to not do so is not a violation of his due process. He still has—
Why not?
Because he has an obligation to fight for his own interests. If the court were to—
Wait a second. He asked to go, didn't he?
No, the record does not indicate that there are any communications between Mr. Hale and the district court. The record—
I'm not asking about the record is that he asked the jail to take him over there.
I think the record is unclear as to what his communication with the jail staff
So
was.
was it an abuse of discretion for Judge Avey not to have him brought over?
It was not. And the record only reveals, I think, that Mr. Hale inquired about the logistics of him being brought over to court on that day. The record, I think, is unclear as to whether the de minimis efforts he took that morning to check up on the status of this case was him requesting to appear from jail staff or him just inquiring, I have a hearing today, when am I being brought over?
Let's look at the facts kind of in the light most favorable to Mr. Hale. And I'm not saying that that's our standard here, but I am concerned about what an opinion that we would write might look like. And in particular, if what happened was Mr. Hale was in jail, Mr. Hale had a person who had the power of attorney asking on his behalf, calling the court without success, seeking to have him brought over or whatever it was that she was asking for him to do. Either the day before or the morning of, Mr. Hale goes to the jail employees and asks to be transported over. And by transported over, I mean just walked over, and is denied that request. And the court knows that he's in jail and decides to go forward with the hearing. Would our decision essentially be sanctioning the ability of a court anytime someone is in custody to enter default judgments against them?
No, it would not. I think it would be consistent with how this court has viewed that situation before. This court has in the past affirmed a district court for even denying the request of a litigant to be brought from jail to be heard on a motion. And that was in Brown v. Maloney back in 1997, 24, Canap 2D 424. It also would be consistent with this court's obligation to dispense justice evenly.
Was that, that case in Maloney, was that for a motion or for a divorce?
It was for a motion. The litigant in that case was in custody. He had filed a motion for an abatement of child support based on the fact that he was in custody. He also had filed a motion to appear. This court remanded the case because the district court judge summarily denied his request to appear. But this court made clear that the district court wasn't under an obligation to necessarily grant that motion. And the distinction here is, in this case, there is no evidence of a request made to the district court by Mr. Hale to appear at his divorce trial. What this court would be doing if it remanded this case based on these facts would be essentially saying that the district court had an obligation to advocate for Mr. Hale, to look at the fact that he's incarcerated, to look at the fact that perhaps he may have a cognizable property interest.
Potentially 50% of the property that he might have an interest in.
Well, he has pro se litigants are held to all the same standards as practicing attorneys. He had the obligation, if he thought that if he wanted to meaningfully fight for that interest, to ensure that he was present. And he took, at best, de minimis efforts to do so.
I'm having a hard time with him being able to attend when he's held in custody. What efforts could he have done? He's got to get the sheriff to take him out.
Yes, and
the court could have easily just asked the sheriff to bring him over for a hearing.
The court could have, but it was not error for the court to refuse to do so. And Judge Al, and
a minute ago, why that wasn't an abuse of discretion, you didn't answer. So why wasn't that an abuse of discretion?
Because the court is not obligated to compel parties to attend hearings in a civil proceeding, which is what the district court would be doing if this court were to rule that it had an obligation to carry him over from the jail in absence of any request by him to be produced for that hearing. And the district court, in denying Mr. Hale's motion.
Counsel.
Yes.
Upon learning, so maybe Judge Alvey at the time didn't know, right? She might not have known, but she knew at the 6260 hearing that he had made that request. Upon learning that information, do you think that it was an abuse of discretion not to at least allow him to have the opportunity to be heard in court?
It may have been, but she provided him. I'm sorry. I want to make sure I understand the question. Upon learning that is the question, would it have been an abuse of discretion for her
Not to
deny him?
reopen and allow for the trial to go forward on the merits?
No, I think it plausibly could have been an abuse of discretion for her to, at that point, summarily deny his request, but Judge Alvey conducted an evidentiary hearing over the objection of Ms. Cooper to ensure that justice was adequately served in this instance and to hear what arguments and what testimony Mr. Hale could provide the court as to what efforts he took to appear on that day. Initially, we were all here on a 6260 motion alleging not a due process violation. It was not alleged that the decree of divorce was void or a nullity. It was alleged that the failure of the court to produce Mr. Hale for the divorce trial amounted to excusable neglect. And a litigant alleging excusable neglect has an obligation to show what that excusable neglect was. And so I think Judge Alvey very appropriately conducted an evidentiary hearing to ascertain what efforts Mr. Hale may have taken and perhaps what his testimony in court would have been that day.
What efforts would have been enough?
Well, the district court in denying Mr. Hale's motion explained that it would have been as simple as sending a letter through the jail service to the court to be produced. Other than that, I don't know what specific efforts he could have undertaken other than making any attempt to contact the district court. There's, again, no evidence of any communication between Mr. Hale and the district court regarding that appearance.
The evidence at the hearing that says there was efforts made timely at that time.
Well, I don't think they were timely, and I still question whether Mr. Hale's testimony about his conversation with jail staff amounted to a request or just an inquiry as to when he was being
with remanding it back for a hearing to determine the equitable division of the assets of the marriage.
I would say there's a couple of things. Number one, first of all, at the initial hearing, despite the fact that Mr. Hale did not participate, the court still conducted an analysis of the marital estate. There was proffers by Ms. Cooper's counsel at the time, Ms. Ikenna, specifically about what the assets of the parties were, what the debts of the parties were. These parties had around $60,000 in debt. That was apportioned. It was not all apportioned to Mr. Hale. Many of the debts were bifurcated between them. But
the house was entirely apportioned to Mrs. Hale.
That's correct. And there has never been an argument.
Were there any assets? There were liabilities that were assessed to Mr. Hale. Were there any assets that were granted to Mr. Hale?
I didn't find
any.
I didn't find any in the decree specifically.
And that's where they would be, correct?
Certainly. But the bottom line here is it has never been alleged by Mr. Hale that that division of property that's memorialized in the decree of divorce from November 1st of 2024 is anything but a fair, just, and equitable division of the marital estate. Basically, what this court would be doing in remanding would be merely acceding to Mr. Hale's request for the sole purpose of giving him an opportunity to provide whatever evidence years after the fact he feels he was deprived of the right to present at the initial hearing. But there is no evidence as to what any of that, there's nothing in the record to suggest.
Because there was never a hearing. So there was never the ability to have a proffer.
From him at the hearing, yes, but he never, in his motion, he never alleged any facts that he felt the court needed to hear and didn't hear that he could testify about that weren't addressed at the hearing. During his sworn testimony at the evidentiary hearing, he similarly did not provide the court with any information as to what he would have testified about on that day. I don't recall off the
equity in the house.
I'm not sure.
So we don't know whether there was a fair, just, and equitable division of the assets of the marriage, do we?
Based on, I can make an argument that there was, based on the facts of this case, yes, but the court had the information it had when it heard the proffers of counsel. There's really no evidence as to what Mr. Hale would have brought to that equation if he had successfully appeared that day. The only issue in this case, as appellate petitioner sees it, is a request by Mr. Hale to have his day in court. That is not sufficient in this case to remand. This again came before the court on a 6260 motion. He has not established that he undertook meaningful efforts to appear in court, and there is no basis by which the district court could conclude that it was appropriate to grant him relief from judgment. The district court made findings to that effect, that he had not carried his burden to establish under the case law that his failure to appear was the result of excusable neglect. There was no effort to demonstrate that he had a meritorious defense to the suit, which again, that piece of it is important because we don't know what evidence he would have brought or what defense against the ultimate distribution of assets he would have brought to bear in that hearing. And
other than it wouldn't have been a zeroed sum game.
Correct. And that's an argument he freely could have made. Regarding the final factor that Mr. Hale, the district court found, failed to establish, and this dovetails with some of counsel's arguments regarding the purported hostility of the district court judge. This was a case where there were other equities that the court considered, namely the fact that Ms. Cooper had specifically pled that there had been domestic violence in the relationship. It was in the record that she was a protected person under a protection from abuse order, which also does give her control of that property and excluded Mr. Hale from that property. And I submit that is an equity that the court clearly from its decision considered. And with respect to the presence
on that, and I know that you're trying to sum up, but on that is so Mrs. Hale had equitable control of that property because of those findings and presumptions. But that doesn't mean that she has entire ownership and control of that property, does it?
Prior to the divorce decree, no, she did not. But what the divorce decree gave her, which I think is eminently a reasonable outcome in a divorce case where there are significant allegations of domestic violence, is it gave her safety interest in that home. To reopen this case is not merely going to place Ms. Cooper in a position where she has to relitigate matters. That wouldn't be any sort of prejudice to prevent the court from ruling that way, but it would deprive her of that safety interest, of the safety that she through litigation had to obtain for herself after she was victims of Mr. Hale's abuse. And so I submit that based on the other factors the court considered at the trial, the decree represents a fair, just, and equitable distribution of assets that Mr. Hale did not carry his burden to establish he was entitled on any level to relief from that judgment, and therefore it is requested that this court affirms Judge Alvey's denial of that motion. Thank you.
Thank you. Further questions from the panel? Thank you, counsel. Mr. Orba, I believe you have 5 minutes for rebuttal.
5 minutes, here we go. One of the things, because it's top of mind that council just discussed, was my client inherited the money that was used to buy the house. And that was brought up in the hearings, and that was something Judge Alvey was aware of, at least at the hearings, that there is a time, source, and manner argument that he was not allowed to make. And that's part of, did he have any sort of defenses to bring to the table?
So do you know the value of the house?
I don't know it either. I'm thinking, I thought about 150,000 was the purchase price, but Judge, I'm a poor source of information because I didn't do the trial, and I'm giving you just my. But they had like $60,000 or $90,000 that they put down that he inherited, and that's his major concern in the whole divorce, from my best of my memory.
Is that in the record, counsel?
I don't know those values. I don't know if it is.
So
I don't know that. I don't.
This is a 2024 divorce?
Yes.
And he's been in custody since how long?
Since October of 24.
Okay.
Yep. Oh, one of the things that in my very limited time is I couldn't get my client to court either. The power of attorney couldn't get him to court. He couldn't get him to court. I couldn't get him to court. I had to have another hearing set. And there's quite a bit of tension in the courtroom about getting my client to court for the 6260 argument. Standard of review. I believe that it's de novo because we're making a constitutional argument. I did plead 6261 and 6, or excusable neglect, under the idea that he was in custody. He, as my judge on my right pointed out, he didn't do a very good job. He made some bad assumptions on that he would be taken to court and didn't ask in advance, but he did have his outside agent do everything that was in her power to try to get Mr. Hale to court. And I do not abandon the argument under 6260B6, which is the last one down there, which talks about it's more the catch-all, any other reason that might excuse it. And that's been found to be a broad and a liberal definition. And what's my case here? Witt versus Elsley says that justice be done in all the facts, and that includes due process. And this was very much a due process argument. And 6260 and due process are not mutually exclusive. I mean, I can argue due process inside a 6260 motion, and that's what I did. And so I believe that we've made our constitutional argument. We cited our constitutional cases. We asked that the case be remanded and reversed, and that the decree be set aside, and that he be given an opportunity for a trial, whether he goes pro se or not, doesn't matter to me. He just needs his opportunity to be in court, and he did everything reasonable, if not perfect, for a person in his circumstances, locked up in a jail and not receiving an inkling of assistance from the court, who knew the circumstances, who knew he was there, who knew he was not happy with the proposed outcome. And could he have done more after the fact? I think so. I think everybody could do more, but he did far more than the nothing before the fact that Mrs. Hale states. So, subject to any more questions, I appreciate it.
Any other questions from the panel? All right, thank you very much. Counsel, thank you for your argument today. We'll take the matter under advisement and issue an opinion as soon as we're able. And at this point, we will call the last case on this morning's docket. Give everybody a couple of minutes to change spots, and then we'll call that case. All right, the final case on this morning's docket is number 127723, State of Kansas Appellee versus Andres Mendoza Rodriguez, appellant from Johnson County. Will the parties please state their appearances?
May I please the court, Grace Tran of the Appellate Defender Office on behalf of Andres Mendoza Rodriguez.
Good afternoon, Your Honor. May it please the court. The state of Kansas appears by Jacob Gonteski.
Mr. Gonteski, have you entered your appearance in this matter?
I believe I did, Your Honor.
Oh, that's fine. You'll check and I'll check, and we'll just make sure that we get it.
I had a note on the docket sheet on my bulletin board, but I had every intention.
I remember.
All right, excellent. So thank you very much for that. Then Ms. Tran, would you like to reserve any time for rebuttal?
Yes, Your Honor, 3 minutes.
3 minutes are granted, and you may come forward.
This case originates from a car stop where a substance was found in Andres's car. But due to several evidentiary issues, it's our position that his conviction should be reversed. First, I'll turn to the issue of the lab test results. The district court should have excluded those lab testing results because there wasn't a reasonable certainty that the substance found in Andres's car wasn't materially altered. So after the substance was found in Andres's car during the car stop, the officer went to field test it. And while that was happening, according to his testimony, it basically exploded over the hood of his car as he tried to open the small plastic bag that it was in. He testified that there was a small amount of the original substance remaining in the little plastic bag. And then, there was substance on the hood of his car, which is also where he frequently and usually tests substances on the hood of his car. So he used his gloved hand to scrape the substance off of the hood of the car into an evidence bag, as well as put the small bag with the small amount of original remaining substance in the evidence bag. And so that was what was ultimately tested and what we have the lab report from. And so the district court analyzed this as a chain of custody issue and found that it should be able to be admitted. But for these chain of custody issues, the evidence should only be admitted if there's a reasonable certainty that the thing that is sought to be admitted wasn't materially altered. And here we don't have that. We cannot be reasonably certain that the substance found in Andres's car wasn't materially altered because what was ultimately tested was what was scraped off of the hood of this car, which is where this officer, by his own testimony, frequently field tests other substances. So
do we know if the small bag was tested?
The small bag was put in the evidence bag along with all of the other substance. And I think my understanding is that point it was like ripped open. So everything is in there together. There's not the small bag with the original substance wasn't separate from what was on the hood of the car. It was sort of all together.
And didn't the officer testify the hood of his car was clean?
He testified that, to his visual sight, it was clean, but he also testified that he didn't, specifically examine it for cleanliness before going to field test, the substance. And again, that it was where, as a part of his, as a matter of course, that's where he field tests things. And so I don't think that we can say here that we can be reasonably certain that the substance that was ultimately tested was not materially altered.
Of course, we don't have to be absolutely certain. We just need to be reasonably certain.
Sure.
And so it would seem that if we were to reverse the district court on this, we would have to we'd have to think, well, maybe there was other crystalline substance on his car at the time. That seems like a strange kind of presumption to make.
I don't think it's that strange to say, Your Honor, that if we have a sort of an uncontrolled, not sterile environment where this officer is frequently field testing substances, there could be a substantial risk of contamination where you have substance that's all over the hood of this car that, we're not checking it beforehand to make sure that it's clean, to make sure that there's no contamination happening. And so I don't think that we can be reasonably certain under those circumstances that the substance wasn't materially altered. And
what does our review of that look like?
Your Honor, it's a little tricky, I think, given how it was raised below as a suppression issue. I think that chain of custody issues are reviewed for abuse of discretion. So I think it would be sort of an error of law to say that when the judge found that there was a reasonable certainty that it hadn't been materially altered. And I think
didn't the quality of the evidence go to its weight for the jury to decide?
I think that's typically in chain of custody issues, although from my reading of the cases, I think that it's sort of a threshold issue, whether, the party offering the evidence can show that there's this reasonable certainty. And then, once that threshold is met, any potential issue, like we said, we don't have to be absolutely certain of, what's going on here. But once we've met that reasonable certainty threshold, then it goes to weight and credibility for the jury after it's been admitted. But I think too, given the facts that the drug dog didn't alert in this case when he went around the car before the substance was ultimately found, given the fact that several weeks before, the same officer had tested a substance found in Mr. Mendoza Rodriguez's car that tested negative for a substance. I think that all of those things sort of can lead us to not be reasonably certain that there wasn't a material alteration in this case, and so that the lab report should not have been able to be admitted. And that sort of dovetails with the Brady issue having to do with the lack of disclosure of this previous car stop that took place 3 weeks earlier. And so it's our position that the state suppressed favorable evidence and violated Brady in doing so. There was evidence that the defense found pretty close to trial that Andres had been stopped about 3 weeks before by the same officer who stopped him in this case, who found a substance in his car again, field tested it, and it was negative. And so, to violate Brady, we have to have favorable evidence, evidence that was suppressed, and evidence that was material. And I think that all three of those prongs are met here.
Explain to me the materiality, if you will.
So when we're looking at materiality, we're looking at a reasonable probability the result of the proceeding would have been different. And I think, so when we're having this, nominal suppression hearing that deals with the car stop as well as the lab report, with the lab report portion, the district court is being called upon to determine the reliability of this evidence. And I think, as well as bad faith determinations of, how did this happen that this evidence sort of ended up in the state that it did. I think knowing that the same officer had stopped my client 3 weeks earlier, found a substance that he thought was illegal, field tested it, and it was negative, that there's a reasonable probability that the result of the hearing would have been different given that information, because
Why?
So the defense attorney could have used that evidence, one, to go toward good faith or bad faith in that situation, given the previous encounter that the officer had with my client, as well as to impeach.
So are you saying the state has an obligation to provide a defendant with every time he or she's been stopped?
No, Your Honor, but I think that given this case and given the specific facts of the case, that the sort of reliability and the evidence handling was in question, I think that makes this prior stop relevant. And the defense did ask for, exculpatory evidence to be turned over, and it wasn't. And so I think under these specific facts,
I'm having a difficult time figuring out how that evidence is exculpatory, because here's what I keep coming down to is that, so he was stopped by the same officer. The officer tested this substance that the officer thought was what we have here, came out that it wasn't, and no charges were filed. So how is that exculpatory as to this stop?
right. So in this stop, the officer's, ability and evidence handling skills were what was in question at the suppression hearing in regards to this lab report, and, whether or not we can rely on this evidence. And so I think the officer's, previous, being incorrect about the evidence that he had found in that case, or in that what didn't become a case, that goes toward the reliability and his ability to make determinations about the evidence and his evidence handling practices in this case, as well as the fact that, the defense attorney argued or asked the district court to evaluate if there had been bad faith in the case. And I think having the history between the parties in question, that was necessary for the district court to be able to fully evaluate the presence of bad faith during that interaction and in the evidence handling.
So, but at the end of the day, the defendant had this information before trial. Was there a request to the district court to reevaluate the suppression finding given the new evidence?
I don't believe that there was an explicit request to sort of have a do-over on the suppression hearing with this new evidence. I mean, I think it was pretty close to trial. And
I had in mind it was within a week.
I think that is correct based on my recollection. And I think that sort of goes to the reasonable time prior to trial that was referenced in the state's brief, and sort of this discussion of, do we have to turn over this evidence, at this point pre-trial? And I think it's a reasonable time prior to trial to turn over evidence that's relevant to a dispositive motion, like the suppression motion, or, if we characterize it as a limiting motion or something along those lines, maybe not dispositive at that point, but certainly relevant to the trial, that it was reasonable for the state to have turned those things over.
And that report of that previous stop, that's not in the record on appeal, is it?
No, I don't think so.
Okay. So it's difficult for us to evaluate the contents of that report to see it potentially would have impacted the district court.
I think that the sort of what we have proffered in the motion that the defense filed, as well as the discussion on the record in the case, is sufficient for this court to be able to review whether or not that that report, is material, is favorable. Just given we have a good amount of information.
And quite honestly, wouldn't your client have known that he got pulled over 3 weeks earlier? Didn't he have this information already?
I think that it's fair to say that he would have known that he had gotten pulled over, but I don't think it's fair.
Charges had not been filed against him.
Sure. I don't think it's fair to say, though, that a layperson would know the legal import of that and the way that could be used in a suppression hearing, used as impeachment material. And so, maybe there was an assumption that his defense attorney would have already known that he had gotten pulled over by the same officer weeks before. So I don't think just because my client, he was there, he would have known that relieves the state of their duty to disclose that information. And unless there are further questions, I would submit the remaining issue on the brief. And thank you.
Other questions from the panel? All right, thank you, counsel. We have 3 minutes for rebuttal, so we'll look forward to seeing you again.
Good afternoon. May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas here. I will do my best to be as faithful to the clock as opposing counsel was. That was impressive. Judges, this case comes before you with no reversible error. Officer Steele conducted a routine traffic stop just outside the courthouse here that night that brought about the charges against this defendant. And throughout that traffic stop, at all pertinent times, Officer Steele adhered to all of the legal requirements to pursue the investigation that led him down the path, ultimately finding a baggie of meth inside the defendant's possessions. At every step of the way, Officer Steele had the requisite reasonable suspicion or probable cause to pursue the investigation that he did. It began with a traffic infraction, and when he stepped to the side of the defendant's car and looked inside, he confirmed the infraction offense. And within seconds of putting eyes on the defendant, he spotted the bottle of Fireball whiskey in the center console. Right at that moment, he had probable cause to believe that a misdemeanor offense had been committed by the defendant. And at that point, he had probable cause that would support a search of the vehicle for evidence of the crime of transporting an open container. And so that's the path that he went down. While he was at the side of the car, that's when he radioed for backup, because as he testified in the suppression hearing, policy requires that he has backup with him when he's going to conduct the search of a vehicle. So within a minute or two of his opening interaction with the defendant, he radios for backup, and he learns that the canine unit is the closest backup to him. The canine unit has the canine that can obviously do an open air sniff, but the canine comes with an officer who can serve as the backup that Officer Steele needs to conduct the actual physical search of the vehicle. And at every step of the way, officers...
What exactly was the point of conducting the physical search of the vehicle if the crime was transporting an open container and I, as the officer, see the open container?
What he was going to need to do is he was going to need to retrieve the open container out of the vehicle, because he had the passenger and the defendant step out of the vehicle when he observed it when he was at the side of the car, and then he radioed for backup, and then he retreated to his car to run the name for wants and warrants. The driver did not have a driver's license with him, although he did recall it in the opening sequence between Officer Steele and the defendant that they both realized that they had interacted with each other a few weeks prior. So in the body cam, you see as much. But he retreated back to his patrol car to run for wants and warrants. And when he did that and radioed for backup, he began drafting up the infraction for the transporting the open container. Backup arrived. He stepped out of his vehicle. When he went up there to conduct that search for the bottle was no longer where he had first seen it in the center console. It had been secreted away somewhere. And so now it was incumbent upon Officer Steele to locate the bottle where it was in the vehicle. So they opened up the doors and began a search of the vehicle for that bottle. They had probable cause to do so every step of the way. And so the canine sniff did not unreasonably extend the stop. It didn't extend the stop because the canine sniff didn't even occur until after Officer Steele already had probable cause to allow him to search the vehicle for evidence of the crime of transporting an open container.
Was it even necessary to do a canine sniff? He already had probable cause to search the car?
It was not necessary. No, but Officer Steele was still acting within his legal authority to do so, given that he had probable cause to search the vehicle. We've often had officers testify in other cases once they establish probable cause, such as the odor of marijuana or something of that sort. They'll often call in the canine to conduct the sniff because their search of the vehicle will be much quicker. It'll be much more efficient with the use of a canine because the canine in those cases will often zero right in on where the evidence can be found. So that will prevent the need of the officer from tearing apart the entire car, looking for where the smell had come from.
But of course, here it was looking for alcohol and the canine would not sniff for alcohol.
Correct. The canine would not sniff for alcohol. The officer was looking for alcohol. When he was looking for alcohol, then he noted that he observed what he believed to be a small amount of marijuana beneath a bag on the passenger, I believe it was on the passenger floorboard. A canine could detect that. Wouldn't always necessarily detect it, but could.
And did not hear.
And did not hear. The canine did not alert here. The officers continued conducting their search of the vehicle and recovered the evidence that they did, and then placed the defendant under arrest at that time. So at all relevant times, the officer was acting under the authority that he was allowed under the law. Additionally, the lab test results were properly admitted. The motion to suppress hearing is where the district court heard evidence from Officer Steele about how the field test was conducted. And it's shown on his body. It was all preserved on his body cam as well. He testified that he often conducts field tests on the hood of his car. It's the easiest place for him to do it. He doesn't like to do it in his patrol car. That's not safe in case there's fentanyl. He doesn't want to be in an enclosed space. The hood of his car provides a relatively flat surface, a desk of his office. And so when he stepped over to his patrol car to do that, he did it in front of his body cam the entire time. And he testified to the fact that the white crystalline substance that he had seized from the car was wrapped in a very small plastic. It appeared to be the remnant of a plastic bag that had been sealed. And he discussed it may have been melted or burned together. So it was held very tightly in that plastic. And when he stepped to his patrol car to conduct the field test of that substance, he had the field testing kit there that he testified only needs a very, very small amount of the substance to conduct the field test. And he went to open the plastic baggie. And when he did so, it tore open and the substance spread all over the hood of his car. And so he then undertook an effort to scoop it back up. He had a gloved hand. His backing officer had a new Ziploc bag, a new clean, empty Ziploc bag. And with his gloved hand and a portion of the field kit, he endeavored to scoop it up and place it in the evidence bag.
There wasn't any testimony about like if he often uses the hood of his patrol car for this purpose. Like, how does he sterilize his patrol car after? There wasn't any evidence along those lines, right?
There was not. There was evidence. He testified that the hood of the car was clean. It appeared clean to him. But I'd also note that what was happening here is the hood of the car was not being used as a microscope slide or as some mortar and pestle in a pharmacy. That's not how he would normally use it. And so in a normal circumstance, when he's field testing a substance, he might gather the evidence from from the car that he stopped or wherever it was, and it may be placed on the hood of his car, but he's not normally scattering the drugs on the hood of his car. So even though he conducts other field testing at the hood of his car, it wouldn't be an ordinary circumstance that that field testing would introduce that substance to the surface of the hood. It did in this case, and Officer Steele was obviously frustrated. That's evidenced by the body cam footage and by his own testimony. It was frustrating for him. It was entirely unintentional. It only detracted from his investigation. And to that end, that's precisely why this error, not error, but this sequence of events goes to the weight of the evidence that would be determined by the fact finder. And so the officer testified about how this all played out, both in the suppression hearing and at trial. And defense was able to make hay of that in impeaching him at trial about how this could have introduced contaminants and how this was not an ideal situation and so on. The defense was still able to elucidate all those facts in the trial and use that against the state to attempt to sway the jury in the amount of credibility that they would place on the lab report. So the lab test results were still properly admitted in the trial, and the defendant was able to impeach those and draw credibility determinations about them. So finally, the Brady violation, the state maintains there was absolutely no Brady violation that was committed here. First off, the idea that this previous stop would be favorable to the defendant in a sense is belied by the redacted video that was played at trial, which removed the discussion between Officer Steele and the defendant about having realized they had been acquainted a few weeks earlier in a different stop. That was all kept from the jury for obvious reasons. That previous stop was not in any way favorable to the defendant. The fact that the officer had an interaction with this defendant on a previous stop, found a substance and field tested that substance and got a negative result was not exculpatory to the defendant. It showed, furthermore, it doesn't conclusively establish that Officer Steele made any mistake in that previous stop. Those field tests, as this court is well aware from a plethora of cases, those field tests are not conclusive results. They're not lab confirmed. They're not used as evidence against a defendant in a trial for very good reason that we use the lab results for those where they conduct them in a accredited environment. But the fact that Officer Steele obtained a negative result in that earlier stop does not conclusively establish that that substance that he was testing was not methamphetamine in the earlier stop. Everything about that earlier stop was inculpatory to the defendant other than the field test result. But the fact that that earlier stop happened was the defendant was obviously well aware that it had happened. Officer Steele was aware. The body cam footage that was released to the defendant in this case made it clear that the two had had an earlier interaction. While the reports of that earlier interaction were not included in the discovery with this case, that was of no effect to this defendant because he would have been able to make no use of those reports in this case. It was neither favorable nor was that information that was not provided to the defendant, nor did it bring about any prejudice to him. It would.
Counsel, the argument was that this demonstrates potentially some bad faith on the officer's part. Could you address that?
I'll address it to the extent that I see that the claim was raised. I struggle to delineate how that evinces any bad faith by Officer Steele. And to the extent that the record here on review by this court draws any conclusions about that, the district court explicitly found officers that there was no bad faith on behalf of on the part of the state here. That's in the record on the suppression hearing.
But that was before this, that was in the absence of this previous report. That previous report was before the court.
But I struggle to ascertain where the bad faith came in that the report was not beneficial to the defendant, other than that he was released and no charges were filed in that earlier event. But the moment it all came up in court, it came up, I believe, in the motion to suppress hearing. At no point did the state prevent the defendant from having a discussion about that with the officer. I believe at some point the state finally objected to questions along those lines and objected on relevancy, but not in an effort to hide or withhold this information from the defendant. Bad faith would require some intentional conduct by the state to withhold this information from the defendant that was obviously plainly exculpatory or favorable to the defendant. But there was no such effort undertaken here. It's not normal course for the state to, when it files a case against a defendant, to dig through all of its archives and records of all of the agencies in the metro to see if they have ever stopped this defendant. And if so, provide those reports and video and evidence, and then tack it on into.
This is a little bit different because it is close in time and it involves the exact same two people. So it's not like having to dig everything out. It's, when you're interviewing your witnesses, you say, well, I just stopped this guy 3 weeks ago.
True. And so we could draw a parallel for a smaller county west of Johnson County then, where I would imagine it's much more common where a law enforcement officer has an interaction with the same defendant. I don't know that it's common course there for the prosecuting attorney to gather all the reports from all the previous interactions and put them together in one packet. If that was significant, then I'd be curious where the court would draw the line on what the state needs to provide. If it was a stop within the last month, if it was a stop with the same agency, but not other agencies in the metro, if it was a stop with the same officer, but not other officers, and so on. There's not a reasonable way to delineate as much. And there's also no need for this court to do as much because nothing about that was exculpatory. Nothing about it was favorable to the defendant, and no prejudice befell him as a result of the state not disclosing as much. So recognizing the clock is encouraging me to wrap up, I would ask this court to affirm the district court's ruling on the motion to suppress and affirm the defendant's conviction and sentence in this case. Happy to stand for any additional questions the court may have.
Any other questions from the panel? All right. Well, thank you very much. I want to commend both attorneys on your use of time in this matter, but Ms. Tran, you have 3 minutes for rebuttal.
May it please the court, I'll address the extension of the stop issue. There was a question about what would be the purpose of searching the car at the initial point of seeing the open container, because the open container was right there. But then it wasn't. But then it wasn't, which is true. And I think that difference is important because in the interim, so the bottle was there and then the bottle wasn't there. And in the interim, there was a call for the canine to come. And while it's true that there was testimony that the canine officer was close, there was also testimony that Officer Steele would have called a canine to the scene regardless. And so I think it seems pretty clear that he wanted a canine there and he wanted a sniff to be done. And there is case law that talks about when a stop has been extended, if the officers discover some evidence afterward that would make it legal for them, to search, that's not going to be saved by the inevitable discovery doctrine because that stuff was discovered after the stop was already extended. And I think that's what happened here. When first we have the bottle that's in plain view that we see it, we have an officer go back to the car, run the check, start writing the ticket, call the canine to the scene, stop writing the ticket, disengage from the traffic mission, go to have the car be searched or to be sniffed by the canine, and then see that the bottle has been moved. And then, maybe we have probable cause to search for that bottle, but the car stop has already been extended and we already have, an illegal seizure. And so I think that in that situation, the case law says that inevitable discovery does not save the evidence that is found afterward because we already had an improper seizure at that point.
But he had probable cause to search the car when he saw the bottle. Didn't matter whether it was moved.
And we would disagree and question that he had probably.
You wouldn't?
Why would that?
Why would there be? Go ahead.
Because I think we have probable cause to search for the evidence of that crime, which is the bottle that's in plain view and sitting right there. I don't know why, when we have a bottle that's plainly in one place, why we would search for that bottle in other places in that car to find evidence of that crime that was seen.
But wouldn't he have the right to search the car to see if there were other bottles?
I don't think that that would be the case, given that just the evidence of the infraction or the crime that was committed is plainly viewed in that circumstance. It's right there. We don't need to search for it. And unless there are further questions, we would ask that Mr. Mendoza Rodriguez's convictions be reversed. Thank you.
Thank you very much. Further questions from the panel?
No.
All right. I want to thank both counsel for their arguments today. And thank you for your written briefs. We'll take the matter under advisement, issue a decision as soon as we're able. Thank you very much. At this point, the court is adjourned.
Man, I didn't even recognize you back there. How's it going? Love it here. With the DA's office. Nice. That's great.
Criminal stuff.
I'm sure.
Yeah.
That's great.
You like it here?
Yeah, well, I mean, I'm not here.
Yeah, but you're traveling today, I guess.
Yeah. Yeah, doing a little travel docket. Report you got here.
Field trip.
It's great.
Oh, yeah, it's a nice building.
I was here a couple months ago. And yeah, it's just you got it's just traffic for you, right? That's all you guys do?
I do, yeah, right. I actually had an open truck.
Oh, really?
Yeah, that was the exact same. Hey, by the way, can you hear me that bottle right there? He goes, "Oh, with this?" He's like, "No, bottle right there." He has a half. He grabs the bottle and he just rounds. He gives to the officer half gone. Go, here you go. That's great. And the judge ruled no. It's like intent. He didn't know it was there. I was like, sure. Okay. I should feel it for up to you.
Yeah, well, yeah. But, yeah, it's wild. But, okay, so this is you're about to start your third year, right? Okay. I always forget where you are.
One below you.
Yeah, or no, because if it was one below me, you'd be
Did you
so
school
far right now.
Were you in school last year? Oh, no, you're two of them.
Yeah.
Okay.
Which is why I always
So you've been like a year out.
Yeah. Yeah. Okay, so you're about to start your last year.
Be a busy year just with working, but other than that,
You're gonna do this all year.
yeah, it's not a year-long contract. So
Oh, did you?
gotta do it.
Nice.
Mhm.
Yeah, of course you do. Okay. Is this what you're gonna do after or?
I will.
Yeah.
I don't know how long
That's
it's
what
gonna take.
Oh, really? Oh, okay, cool.
Well, how's life otherwise? Good?
Yep, we,
I call another chief.
Brandon and I are, well, still enjoying Westwood.
Yeah.
I saw Steve the other day.
Oh, yeah?
We had
See him?
lunch. Well,
just
we,
came out.
yeah, I went to the office.
He was like waving at me, so I'm not coming over there.
Maybe he's going to like Nepal.
Yeah.
Isn't that crazy?
Yeah.
I gotta touch it about that. That was a couple months ago.
Like
but
of
yeah.
all places. But I didn't know she was, I didn't realize she was going, I guess I did know.
Here, I gotta get there, but.
Yep, well, I'll let you go.
Yeah, I hope they hold the door for you.
Yeah, they should. They should.
Good to see you.
Don't get locked in.
Yeah.
See you, Sam.
Thank you for your help today.
Welcome.
out your, what do we have in this?
The timer.
I'll get, can I come back after?
Okay.